Good morning and welcome to the Planning and Placemaking Committee of the 10th of April 2024. I'm Councillor Ian Massey and I'm the convener of this committee. And I'll introduce the top table to you. From my far left is Councillor Grant Stewart, my vice convener, Miss Jessica Gill, Democratic Governance Officer, Mr Jeff Fogg, Legal Manager, and on my right is Mr Christian Smith, Development Management and Building Standards Service Manager, and Mr Paul Williamson, Team Leader, Local Developments. Now for a bit of housekeeping, as this is a hybrid meeting, members joining virtually are reminded that if you leave the meeting during consideration of any application, you are unable to participate or vote on that item when you return to the meeting. This also means that if a member loses their internet connection during the consideration of any item, they should not vote on that item. Please advise the clerk via the meeting chat that you are leaving the meeting, or if you have lost your connection and are therefore unable to vote on that item. And whilst we are operating as a hybrid meeting for the proceedings today, can I remind councillors and officers to use the chat box to attract my attention, which all members should have access to. Q for question, C for comment. Can I please remind members, officers and those in the public gallery to switch off all electronic devices onto silent mode? And can I also request that those in the public gallery remain quiet during proceedings and do not move in and out of the chamber during items of business. Comfort breaks will be scheduled as required. I will now ask the clerk to confirm any apologies and the attendance of those in the chambers and online. Thank you.
Thank you, Convener. We have apologies today from Councillor Braun with Bailey Ahern substituting and Councillor Cuthbert with Bailey Brock substituting. We have two members online who I'll ask to confirm they're present, please. Councillor James.
Good morning, Jess.
And Councillor Leishman.
Good morning, Jess. I'm present.
Thank you. All other members are in the chambers, Convener.
Thank you. Declarations of interest. Do any members have any declarations of interest? DI in the chat. Thank you. No declarations of interest. Item 3, the minutes of the meeting of the Planning and Placemaking Committee of the 13th of March. These are not ready yet. They will be coming forward for approval at the next month's Planning and Placemaking Committee. Item 4, deputations. Can I ask the committee if they agree to hear deputations on item 511, 512 and 513? Thank you. On behalf of the committee, I'd like to extend a warm welcome to the deputations and members of the public present today. Your request to speak has been granted. You will be called to the lectern as we reach the relevant item on the agenda and permitted 10 minutes to speak, followed by a period of time for questions from members. It is requested that the content of your deputation is kept relevant to the planning consideration in relation to the business being discussed. Please also ensure that when answering questions, your response remains relevant and direct to the question asked. And I'd also like to inform the committee that under Standing Orders 19.9, I have granted consent to Councillor Grant Lang to address the committee in relation to the planning application 23/01255/FLL, siting of a mobile crushing and screening plant at Newtile Farm, Dunkeld, and also to Councillor Stuart Donaldson to address the committee in relation to planning application 24/00043/FLL land west of Ruckleside Farm, Comrie. They will address the committee prior to questions. Will also have an opportunity to ask questions of officers alongside the rest of the committee when that point is reached in the proceedings. Item 5, applications for determination. First application, the local application, and it is for the siting of a mobile crushing and screening plant for a temporary period at Newtile Farm, Dunkeld. And to introduce the report is Mr. Smith. Thank you.
Thank you, Convener. This application relates only to the siting and use of slate waste processing machinery within an area where this waste can be collected and exported without the requirement for planning permission via permitted development rights under Class 66 of the General Permitted Development Order. As such, only the issues associated to the use of that machinery which can be considered. The proposed and similar machinery have previously been used across the waste slate deposit area, including the area subject of the application, although the last planning permission expired last summer, with this application seeking additional time, which reflects that it is anticipated to be 2 years until the surrounding reserves are exhausted. Given that there are 2 conditions requiring information to be submitted for approval, it is now the recommendation that condition 1 is adjusted to align the 2 years with the approval of this information. All machinery has now been removed from the site. This came to the attention of officers following the drafting report, which indicates that one of the machines remained. Environmental health have been consulted, and reflective of the experience associated to the history of similar operations up to last year via previous planning permissions, they are content that noise and dust associated to the machinery's operation can be adequately controlled via the same conditions as previously applied. Additionally, and for clarification, although there is much discussion and representations, planning aspects associated to the wider waste slate deposits and applications associated to these aggregate reserves are not considerations for this application. Neither are other developments in the vicinity, such as a farm access track or planning enforcement investigations related to complaints received. I just wanted to highlight that there are 2 typo or drafting issues in the published report. The first in the first sentence of paragraph 51, where the word insert should read inert as it relates to waste. The second at paragraph 66, where the final sentence is incomplete. However, given the context of that section is discussing the machine which remained on site at that time and has since been removed, the issue is no longer relevant. I'll now take you through a short visual presentation to set the scene. First slide, please. This image is an aerial view with the location where the machinery is to be sited and the route to the A984 highlighted in red. Residential properties at Deans Park are some distance to the north, whilst a closer residential property is at the junction of the A984. Slide 2, please. This next image is in map form, again showing the application area in red. More features are identifiable, including the residential properties at Deans Park. Next slide, thank you. We then have a closer image with the machinery to be positioned within the red highlighted rectangle with some of the contouring indicated. Next slide. This shows the screening machine proposed with some of the detail associated to it. Next slide. And this shows the crushing machine again for information. Now we'll give some visual context to the site and surroundings through a series of photographs. This first image is the access junction off the A984 with the nearby residential property visible to the left of shot. Next image, please. The next 2 images show the access track which passes to the rear of the aforementioned residential property to the area where leading to the area where waste slate is being removed and transported to the 2 local development projects. Next slide. This image looks across the area where slate waste is gathered and towards the location where the machinery would be sited, which is behind the blue container visible in the left centre of the shot. Next image. This last image shows a second aerial shot and the site in the lower right centre, showing the distance to Deans Park, which is beyond the exposed area of northern slate waste, which is not subject to this application. We then return to the plan and the application site again outlined in red and the end of the presentation. Thank you, Convener.
Thank you, Mr. Smith. We do have deputations on this, so I'll now hand over to the Vice Convener for the deputations procedures. Thank you.
Thank you, Convener. Can I call on Mr. Wiley and Dr. Wigsell from the Dunkeld and Burnham County Council objectors to the application? Gentlemen, you've got 10 minutes each for your deputation. I'll give you a prompt after 9 minutes. And I'll start the clock whenever you're ready. Could I ask you to pull the microphone up so people online can hear you. Thank you.
Good morning, committee members. My name is Alan Wiley. I'm the Secretary and Deputy Chair of the Dunkeld and Burnham Community Council. With me is Dr. John Wigsell, Treasurer of the Community Council. Good. All right. Also in our entourage are a number of residents of Dunkeld and Burnham. I'd like to thank you, convener, for the opportunity to address the committee today on behalf of the Community Council, the community of Dunkeld and Burnham, and specifically the local Deans Park neighbourhood. We have circulated our case against the planning application to all members of the committee, and thank you for your consideration in taking account of our statement alongside our previously stated objections. We have also provided a supplementary statement to development management relating to the effect dust and noise as statutory nuisances have on a community, which I trust you have all had an opportunity to digest. The site and the applicant have a significant history over the past 14 years involving unauthorised activity, retrospective planning approvals, continuous breaches of suspensive conditions and enforcement actions. This has also included concerns regarding the potential disposal of contaminated waste on part of the site in the absence of waste transfer notes. Coupled with this, the most recent breach involves a failure to remove the crushing and screening equipment from the site and continued operation in the absence of planning permission. Now, I realise that I've just been informed that it has been removed, but nonetheless, we would like to present a case on the overall plan. The planning offer has acknowledged this, yet chooses to accept this breach and to recommend approval for this planning application. This specific application is also associated with separate applications to commence further quarrying by the excavation down to a depth of 14 metres into the hillside, affecting the natural environment, habitat and wildlife inclusive of rare and protected species, and in contravention of the local development plan. Indeed, the applicant has also been the subject of criminal proceedings through Perth Sheriff Court for the destruction of a bat cave of the New Tile Quarry site. The operations have also impacted upon internationally recognised climbing facilities at the quarry. The original planning approval permitted the siting of the crusher on the west side of the road outside the quarry. Regrettably, the actual siting of the rock crusher was in the quarry adjacent to the domestic housing at Deans Park. Furthermore, the applicant is now planning to excavate and quarry around the back of residential properties and into the New Tile Hill itself. The operator has not been licensed for quarrying of facades or transfer of contaminated waste, but has been permitted to operate a business model that has involved quarrying slate, crushing and screening it on site, loading the crushed slate onto large uncovered lorries, transporting it down a dangerous B category narrow winding road and through villages to unload the material at construction sites. This business model has then seen the lorries load up with waste materials from the construction sites, driving back through the villages and back up the same roads before depositing this material on a site with planning permission for a fictitious farm tract, which is 100 metres wide, with an exemption certificate for waste disposal permitted by SEPA. Integral to this has been the siting and operation of this crusher and screener plant. Again, this has been sited and operated without the required permissions. There are national health and safety regulations and codes of practice pertaining to quarrying, but these are not being applied or adhered to in this operation. No spray booms, no noise or dust mitigation, no risk assessment or safety measures on site to protect staff and locals, and no physical covers have been installed over the sites or lorries. Of all our concerns, the negative impact on the health of our community is of paramount importance. A miscellany of quarrying and extensions to quarrying activities has been refused both nationally and internationally due to environmental damage and the significant health and safety risk associated with such operations. In particular, the severe health impacts arising from exposure to silica dust is a major risk, particularly where there is no mitigation or enforcement of stringent health and safety and public health measures. We are increasingly concerned about the potential damage to our community's health and well-being over the past 14 years. Any extension of work on the site will only enhance these concerns. There is also a considerable noise pollution problem caused by the operation of such plant and machinery. Given the location, this affects the natural wildlife, local neighbourhoods, and the wider population as the noise carries right across the Tay Valley to Burnham, disrupting people's lives. Worryingly, this application contains no proposals on updated noise and dust migration test data, particularly when neighbourhoods are well within the danger threshold. Indeed, some neighbouring properties lie within 10 metres of the site operations, exposing individuals to huge health risks. The recommendation from the Planning Office is for approval in spite of the objections, the environmental impacts, damage to wildlife habitat, and most significantly, the risks around public health and safety. The proposals also contravene the local authority's own local development plan. The community of Dunkeld and Burnham are puzzled as to why council officers would consider approval of this application and have to question why this council would wish to accept a recommendation for approval for this aspect of an operation when nationally and across the globe these applications are being rejected on the basis of public health concerns. Somewhat oddly, the Community Council were invited to consider withdrawing their objection, allowing this matter to be dealt with by officers under delegated powers. However, we have persisted in raising these objections to the Planning Committee because of the serious public health risk, and will continue to do so in engaging with the Director of Public Health for Tayside. Finally, as confirmed by Development Management, much of this business operation has been undertaken under subcontract to Perth and Kinross Council's own main contractor on its prestigious Tay River Crossing capital project. We feel the nature of this activity, abuse of planning conditions, and legal issues raises questions around PKC's contractor approval procedure and potential conflicts for the authority. Accordingly, we ask the committee reject the officer's recommendations on the basis of the serious risk to public health and refuse the application, understanding that this needs to be seen in the context of the wider operation and associated risks. Thank you for listening, and now I'd like to welcome questions from the councillors, which my colleague John Wigsell and local residents will be pleased to provide detailed answers.
Thank you, Mr. Wiley. We'll give it a moment for the members to populate the chat function. Councillor Allen.
Thank you, Vice Convener. Thank you, Mr. Wiley, for your presentation. It's more clarification rather than questions I've got for you. And if I picked you up correctly, you're suggesting that the machinery is not going to be situated within the site boundary. And it's going to be closer to Dean's Park. Is that what you suggested? Sorry, yeah.
Okay, yeah. Yeah, it's a fair question. In reality, what we found is through the corporate video of Mills, our own videos, that the rock crusher actually wasn't sited where it said in the application. And the corporate video shows it behind the Dean's Park. In fact, it shows it in many positions, but not where the plan was in the original application. So this is the big issue. It's actually well inside the safe distance is 500 meters. The plan says 160, but it's sitting in some cases at 10 meters. And you just have to look at the residents' gardens, vegetable patches, car roofs, and it's covered in silica dust. And this is not just now, this has been going on for a decade. So what you see in the plan is not reality. In fact, if you looked at the corporate video which Mills produced, you can see the screener and the crusher and the excavators right behind Dean's Park. So I don't know if you had a chance to look at their video, but it's very obvious what's going on. And our videos and our images show the same thing. So unfortunately, what was going to happen didn't happen.
And my second point was a reference that you made to health and safety on site. You suggested that there was no health and safety on site. Can you elaborate on that, please?
Sure. There's actually 3 or 4 areas where there are material and serious breaches in terms of health and safety. The first big one is the quarries reg, which is a large pack of basically procedures which need to be enacted. And when you look at that and compare it with the Mills operation, pretty well everything is not adhered to. As Alan mentioned, there's simple things like spray booms, uncovered lorries going through Dunkeld, the dust pouring off the back, in fact, bits falling off the back. So I mean, there's a load of stuff in the quarries, like Kosh, simple things like masks for dust, ear protection. Again, in the corporate video, it's quite amazing. The people in it have no ear or masks for respiratory purposes. So, you know, Kosh assessments have clearly not been done, or if they had, they're not being used. Environmental Protection Act, I mean, most of the breaches, the breaches in planning contradict the EPA. So I mean, there's a lot of stuff in there. And the other interesting thing is, if you compare it with, for example, the Calais quarry, which is owned by, part owned by the council through the committee on the Tayside contracts. That quarry has environmental standards, has quality standards, has caution place. It's just immaculate. The question is, why is one quarry under the guidance of the council absolutely professional and perfect, but the other is an absolute disaster? And we can give the comparative figures, but for example, on noise and dust, there were very, very thorough surveys done for both of those at Calais. But yeah, sorry. So the point I was going to make was that the standards in terms of dust migration at Newtal are just not there. And no testing's been done in dust, no testing at all. And yet we have the potential for, you know, silicosis, COPD, asthma. No testing's been done, which is shocking. Yeah. Sorry.
Councillor James.
Thanks, Vice Convener. And thanks, Mr. Wiley and Mr. Wigzell for the deputation today. Very difficult for us on planning, and you mentioned a lot of stuff about abuse of planning. Are you aware that today we're only looking at the siting of this machine, and also that we're quite heavily bound by NPF4, and I'm looking particularly at policies 33 and 49, which were used for a similar quarry not too far from Dunkeld. But are you aware that a lot of stuff that you're talking about is without our gift today?
Yeah, I'm aware of the other quarries, etc., which you mentioned. However, for us, this is just simply about public health and silicosis. And you have all these policies and procedures, but almost every rule in the game has been broken. Not this year, not last year, but for 14 years. So the policies may be there, but in actuality, in terms of EPA, you know, we've failed to meet those standards.
And if I can just add, I mean, yes, we appreciate today is about one specific planning application, but in all honesty, as far as we're concerned, we're looking at the wider context, and we are aware that there are two further applications. And if you like, we're just getting our ducks in a row to prepare for what would happen. And as John has said, we consider and we appreciate you need to follow policy, but as far as we're concerned not about your policy, but we're concerned about the health and safety of our community.
Could I, sorry, just add to that? It's an extraordinary situation because why would you put a rock crusher in that's not going to be crushing rocks? So this application is intrinsically linked to the other two. So you can't have the crusher on its own or the screener on its own. It's an operation and it's quarrying as defined in the quarries regulations. So it's not sensible to suggest that placing the rock crusher there will have no effect. Because the next stage is to start the quarrying and use the crusher and the screener because they're integrated, and that comes up in all the applications. In fact, the screener is still sitting there and it's supposedly being maintained. I'm not sure what that means, but it's another piece of equipment with high decibels. Anyway, sorry.
Councillor Harvey.
Thank you, Vice Convener, and thanks, gents, for your presentation. The map was up on the screen a wee minute ago. I just was wondering the location, if it's maybe not your question directly, but the crusher will be in that area marked in red within the map there. Where roughly would you say the location is going to be? Yeah, sorry. Historically, and if you know where it is going to be in the future, yeah.
Sorry. That's better. So the rock crusher was sitting on the south sector site. It should have been removed last July. So that was a planning breach, which was addressed because the crusher crossed the bridge in Dunkeld last Wednesday about 1 o'clock in the afternoon. So that's gone. But the screener, big screener, is still sitting there. So that's an issue. The other positions of the crusher, sorry, of the rock crusher were up behind the houses, and also the noise measurement done 14 years ago wasn't even in the quarry. It was on the west side of the road. So the noise data was irrelevant because it wasn't anywhere near where the crusher actually ended up. And why you'd have the crusher on this farm track, I do not know, because the excavators were all in the quarry. So the crushers actually moved around, and so have the screeners as well. And that's the issue. What you see in the application is not what you see in reality. The corporate video supports that, and our videos support that. So that's the big issue. So.
No, thanks. And I'm just looking at Google Maps here as well, and it's pretty obvious. There's been a lot of movement around that area, and particularly in behind some of the houses. But as far as you understand, the position it's going to be is will be one going forward will be within that red zone there.
Yes, correct. The problem is, though, there's absolutely no data on dust migration and noise because it hasn't been done. So citing it there is fine, but they need to do dust migration, particle size, distance travelled. And we know historically that lands on the houses, cars and vegetable patches. And okay, fine, okay.
No, it's okay. Thanks, Vice Convener. That answered my question anyway. Thanks again.
Bailey McLaren.
Thank you, both. As colleague Ian James has pointed out, this is up for recommendation for approval. We're bound within policies. There are conditions attached to this recommendation. From your deputation, are you suggesting that you feel that these conditions are not strong enough to ensure public health? Because what you're highlighting to us is public health risk, and if so, what other conditions do you feel could be added to this this application if we approve? Thank you.
Okay, the 2 points to address Councillor McLaren's questions. First one is the suspensive conditions have been in for 14 years and they've been breached for 14 years. And you just have to look at the list of retrospective planning applications and the enforcement action taken against the contractor. So the suspensive conditions are just ignored. And that's obviously critical in determining dust migration and noise. The other point, which again I'd reiterate, is there has been no testing done. So no one knows the effect of the dust other than the residents who have it precipitated onto their cars, gardens and vegetable patches. So it's a fair question, but they don't apply the conditions. And you can see it from the retrospective planning and the enforcement orders.
Gentlemen, there appears to be no further questions, so thank you for your time. You're free to go. Can I call on Mr. Booth, agent for the application? Mr. Booth, you're probably aware that you've got 10 minutes for your deputation. I'll give you a prompt after 9 minutes. So whenever you're ready, and that microphone will probably need pulled towards you. Whenever you're ready, I'll start the clock.
Good morning. As noted in the officer's report, the extraction and removal of waste slate from this site is permitted development. Accordingly, this application relates solely to the operation of the crushing and screening plant to process slate before it leaves this site. There's definitely been some confusion here with the Community Council. They're referring to about 3 different sites. This is a single site. It's the red line that's shown within that boundary, and it's taking waste slate that's attached to the area that says tip just behind that boundary. That material goes from there and it goes to market. It is not actually linked in with other operations. There are other planning permissions in that area which allow the operation of that crushing machinery at these sites, and that is when that operation has been undertaken there. It's not a case of a single planning application here and it's just been moved all over. This application relates solely to that site. When operations commenced on the site, the planning authority were advised that the likely timescale for the removal of slate would be 5 years. Planning permission was initially granted for the processing of slate for a period of 3 years, during which times operations have been undertaken at this site without complaint. This application simply relates to a continuation of the previous permission for a further 2 years to allow the continuation of these operations and the completion of the operations that were proposed at the start. As I said, no issues have been identified by any of the statutory consultees, and no environmental or amenity issues have been identified during the previous operations at this specific site, which is what we're looking at today. It is therefore reasonable to assert that these works could continue without impact. I'll point out in relation to the site, there's a single property which is related to the south, and it's about 160 metres away, and that property didn't complain for the previous application. It hasn't complained throughout the whole time that that operation has been undergoing, and it hasn't complained to its application. There are no other properties in the general permission proximity of this proposal. Representations have been made to the Planning Authority asserting that various breaches have occurred as a result of the operations undertaken by Mills Contractors Limited. As can be seen from the report to committee, the majority of these reports have been investigated by the Council and no breach has been identified. It should also be noted that these complaints related to other operations that are up at other sites. There have been no complaints and issues in relation to the application before the committee today. The company works in full compliance with health and safety regulations. Indeed, the actual advisor for the company is an ex-Quarries HSE officer. As noted in the report to committee, current policy seeks to minimise the use of primary aggregates and to encourage the recycling of waste materials. The proposed operation therefore assists in the national and regional objectives to achieve zero waste. Planning Policy 1 seeks to ensure that developments do not have an adverse impact on the local environment or amenity, which has been demonstrably achieved during the previous 3 years' operation at this site. I would note that the type of plant that's being used is authorised by SEPA, and that that authorisation ensures that you're looking at a plant which can actually operate in the circumstances we're proposing. There are no issues with respect to dust or noise, and where there are considered that there could be potential issues, these are controlled by the planning conditions currently in place for the previous application, and which would be carried through into the new application. Where there are no identified impacts, Policy 8 supports proposals that offer opportunities for business diversification, providing that the proposal contributes positively to the local economy through, amongst other things, the provision of permanent employment. Mills Contractors are a local family contracting firm with over 40 years' experience employing 12 local people within Perthshire. The company works within the construction industry, providing products and services locally to building and construction projects and various housing developments in and around Perthshire. The company has a fleet of tipper trucks, road sweepers and excavators, and holds a SEPA registered waste carrier and broker licence. The company contributes substantially to the local economy by means of local and national taxes and through the use of local suppliers and providers of fuel, tyres, insurances, garage and maintenance services and other professional services that the company requires to maintain the continuity of its business. Mills Contractors are environmentally conscious in their operations, endeavouring to maintain a low carbon footprint due to their continual renewal of their fleet and equipment and the ability to recycle and reuse construction waste materials wherever possible. In summary, the continuation of the proposed operations that are the subject of this planning application will assist Mills Contractors in the continued supply of the local market in Perthshire and in the continued employment of a valued workforce. The proposed works have been demonstrated to accord with the policies of the local development plan. No significant environmental or amenity issues have been identified by consultees, and these works are simply a continuation of works that have been undertaken for the previous 3 years at this site without complaint. Accordingly, we suggest that it would be appropriate to grant this planning permission. Thank you.
Thank you, Mr. Booth. Are you willing to take questions from members? Okay, we'll give it a moment for the chat to be populated. Councillor Harvey.
Excuse me. Thank you, Vice Convener. Thanks for your presentation. It's similar to the question to the objectors about just about the exact location. It's more to do with the access to the site for where this crusher is. Again, considering this map here, is the only access I can see from looking at Google Maps is kind of round the corner, quite close to where the houses are in the north. I can't see any access on that flat bit of roads running kind of east to west there. Could you kind of clarify where the access to this crusher will be from the main road there? Thanks.
access to the lorries is on the corner of the road, just as it comes round. That's the only access into the site. That is access which is permitted for the permitted development at a site for the excavation and removal of slate waste. Now, as I say, this planning application, it doesn't relate to taking materials off site. It relates to the processing and crushing. That if they weren't allowed to process and crush here, the materials would still be taken off site, but they would have to be processed and crushed somewhere else.
Okay, thanks. It wasn't a leading question. I was just wondering. Thank you.
Councillor Allen, I'll take your first question.
Yeah, thank you, Vice Convener. Thanks, Mr. Booth. They're kind of interrelated, but let's go the way you want me to go. I would like you just to give some regard to some of the comments that were made about health and safety on site. And although you've just mentioned it there, I'd also like to come back and say specifically with regard to product being moved in lorries without coverings.
My understanding is that all lorries are sheeted. There may be the occasional lorry where it's independent contractors come in for a load and perhaps they may not have a sheeting, but in general, all lorries are sheeted that are leaving the site. With regards to health and safety, there were comments in relation to a video. This was a video showing plant being operated. The person was standing in front of that plant as a demonstration of a plant being operated and was speaking to a camera. So they were not standing with ear defenders on, etc. That was simply to show a plant operating. It was not a health and safety demonstration, I would point out.
Councillor Waters.
Thank you, Vice Convener. Thanks for your presentation there. Just in relation to dust, dust can, you mentioned that it will get covered in previous planning applications it's been in, but can I ask you to go into a bit of detail on what you do to ensure, to deal with, to mitigate any dust pollution? And just following on from your other comment, but still in relation to dust, that would it not be your responsibility to, as the contractor, to ensure all lorries do have dust coverings on them when they leave the site? Thank you.
Yes, it is the contractor's responsibility, and I think that's something, if there are the occasional lorry going out there, that my client will actually look at and ensure is completely adhered in the future. With regards to dust, the crushing machine does actually have a sprinkler system which dampens materials as it goes into it. The screen, which is taking out the smaller size stuff, that's materials that have been dug straight out of the ground. They have an inherent moisture content. It's just going from the ground damp through the screen, where it's getting broken down. There are sprinklers with the crusher. One thing the Community Council did refer to the actual video demonstration of the plant. In that video demonstration, if you look at it, you will see that there is not a significant quantity of dust in the air, that you're standing literally at point source and the amount of dust is actually fairly limited. But other operations at site, yes, there is the requirement for sheeting, say, for materials going out. If there is excessive dust within the surrounding area, then potential for dust uplift, then dampening can be undertaken round about the plant while it's working as well.
Sorry, Vice Convener, can I just ask a wee relevant supplementary? Just on windy days, what happens when you have a windy day? Do you close down operations, or what happens?
Well, dust management is an operation where it is largely down to visual inspection and reaction. So on a windy day, the visual inspection identifies that if there is potential dust uplift, then that is when dampening would be undertaken to ensure that there is no dust uplift. Because basically, you need a speed of wind over 5.5 meters per second, and you need a dry surface for there to be a potential that dust would actually uplift and then become fugitive dust.
Thank you.
Councillor Allen, Councillor Waters asked your question. Are you happy with the answer from Mr. Booth?
Another one. I have another question. Yeah, thank you. This has been requested again as a temporary measure or for a 2-year period. Can you give everybody a commitment on a finality? When will this end?
At this site, as I stated earlier, at this site, the applicant originally did ask for a 5-year period to work this site, and I'm not sure if it was just procedure, whatever, but for some reason 3 years was granted, not 5 years, and that's a matter of fact. So basically, this site was never going to be completed within 3 years. That's why we're going back and asking for the further 2 years now. Our feeling is that if the Plan Authority thought, well, we'll give 3 years, and that ensures that it's a limited period, we can see how things go. There's been no complaints, there's been no issues with dust, with environmental health, nothing at all in relation to this site. So we feel that it is reasonable to carry on for the further 2 years to complete what was proposed to be a 5-year project in the first instance. And this will be completed at this site within the next 2 years.
Councillor James.
Thanks, Vice Convener. Thanks, Mr. Booth, for your presentation. Can I ask, do you know if your clients have received complaints direct from the community over dust in the area, please?
I believe there have been complaints in relation to other operations. There have been no complaints in relation to this site.
Mr. Booth, there appears to be no further questions, so you're free to go. Convener, there's no further public deputations. I'll hand back to yourself.
Thank you, Vice Convener. Can I call Councillor Grant Lang to the podium? Thank you. Councillor Lang, you've got 5 minutes to speak. Then will are you prepared to take questions after?
Oh yes.
Thank you.
First of all, thank you for allowing me the chance to speak and to be able to ask questions later. I'm here today, obviously not as leader of the council, but as one of the elected members for Strathty, into which this falls. Personally, I find this a difficult one to come forward, because on one side of it we have a very successful local business who does a really good job in their transportation and that, and support them. They support jobs within the community. I think they would have to agree, or I would think they might agree, that they could have performed better in this different venture from what they usually do. I think it's a different area of work, and I have had no other issue that has hit my mailbox so often in the last 10 years than this one from local people. I don't know how long Mr. Booth's been involved in the project. I can't say. I've never spoken to him. I've always raised things privately, not publicly, and I've raised them through our enforcement team. So hopefully I'll be able to ask some of the enforcement team about some of the things that haven't appeared in here that they've gone to look to. I think if the team could go back to the very first slide that Mr. Smith put up, it would be really useful, because it would show some of the complaints he gets about the waste and dust coming down on the main road. And I think that was a very good shot, the very first picture, just showing where the access was. And you could see that on a typical day, what cars and vehicles have to go through. They then pick this dust up and drive it around. Now, if I hadn't been elected again, this is onto the main road. You see the track coming down. Now, if you were a responsible developer of something and you had road sweepers, etc., you'd be using them that's on a corner. The stuff, the silicate that comes off when it gets wet, gets very slippy, sticks to tyres, it's like slip, and you can drive it, then goes round the houses. If I hadn't been elected, I think I could have got a job as a window cleaner. And if I only had the 8 houses on that road from there round, I'd managed to survive, because I'd have to clean them 4 or 5 times a day on a day like this. So it's not just about whether the site should be there, it should be operating better. It should be operating better so the people aren't getting the silicates, aren't getting the dust. The crusher, do we need the crusher? Why not take it away to another area? And if, it's permitted development, drive the slate away. take it, crush it, process it in someplace far away from the houses? Why is that not an option? Why is the option that it has to be in an area? The reason why there'll not have been a lot of complaints, and a lot of them come is because they said, well, we've only got 3 years to go. We've only got 2 years to go. Oh, we've only got one. And here we are going again. Oh, well, don't be too upset about it. Don't complain too much, because in 2 years' time, we'll move on again. And then there'll be something else coming. I don't know how many of you have actually been out and looked at the site. Don't know how many of you have actually, these people, that house there and the other ones, they've been living with this for 10 years. And you're sitting here looking at 3 pictures and making a decision. Well, that's up to you guys. That's your job. I've done my job here today. I've come and represented the 10 people who maybe don't have a voice. And I do have sympathy with Mills contractors, because I do see the lorries driving through my village and that. Respectful. They've mixed female drivers as well. Fantastic. Slowly through the village and doing a good job. But this is something that needs to be done better. I don't think Mr. Booth has been there long enough. I know that he's got experience in other mining areas, and his name comes up when you're talking about in Blairgowrie, etc. Using that, but it's up to you guys here to make a decision and put in conditions, and then it's up to the enforcement team to actually enforce them. Because I think that the period that our enforcement team were meant to be enforcing these conditions, they were so understaffed that you would call them up. They would take a month to be able to go out because there was only 1 or 2 of them. There's no point in putting conditions in if you're not going to enforce them. Thank you.
Thank you, Councillor Lang. Do members have any questions for Councillor Lang? Councillor Allen. Oh, Bailey Ahern, sorry, I didn't see you there.
Thank you, and thank you, Councillor Lane, for your comments there. You mentioned there that you've had more complaints about this operation, and I assume you're talking about the entire operation covering both sites. And we also heard in previous deputation that there hadn't been any complaints from this house, which you've just said gets covered every single day. Can you just clarify whether you've received complaints from this house, and how many of your complaints have been purely on this location and not the locations of the quarry further around, which is closer to the residential houses?
None from that house, because I know the person that stays in that house. But from the ones going round to the toll house, which is right in the corner, that is because you're coming out there. If you're heading through Dunkeld, you turn right. You're only a couple of 100 yards away, and the slip on the road is running. Some days, because it's very thin, it depends how much rain it is, but it also runs down when they're washing, because that's down a hill. Water always falls downhill. On the other side of that road, the drop's like this, because it goes right down into a field and then it goes to the River Tay. So I don't identify them house by house, I'm sorry, and I don't have the data. It's just been, to me, it's been a constant. And yes, it hasn't been on this site, what they were specifically talking about today. And this is a problem with planning. And this is why I stay off planning, because I couldn't stand it where you're looking at something in front of you that has such a bigger effect, and you only look at that this time, you look at this bit over here the next time, and you look at the next bit the next time.
Councillor Allen.
Thanks, Convener. Thanks, Grant, for your deputation on behalf of the local people. They say there's no such thing as a daft question, but you're going to get one, okay? Because I don't know. Silica and silicosis, are they byproducts of slate crushing?
You'll probably get a silly answer or a daft laddie answer, because I'm not exactly sure. I think silica will come from silicates, which are part, and I'm sure silicates will be found in more than one sort of rock. But some of the other people may know better. But that's what my understanding is. Maybe the officer would ask, but I would imagine that silica is a silicate, and it will be part of when you crush a rock, silicates can come in there.
Thank you. Can we try and keep our questions to questions that Councillor Lang may be able to answer, rather than scientific questions? Thank you. Thank you. Bailey McLaren.
Yeah, thank you, Grant. As you're alluding, you know, we're restricted in our view on the application. So yes, hearing all the deputations and the concerns, the wider concerns, yes, we're not dismissing them. But same question to you as I gave to Mr. Wigsell, Mr. Wiley. There are recommendations, conditions under the recommendations here for this approval. Do you feel they are robust enough, or is there some other conditions that you feel could be added here?
I think on paper they're robust enough. As every time something comes out of this committee, it'll be robust enough. But
Councillor Harvey.
It's probably the silica I'm swallowing. Councillor Allen, you can ask me, I'll tell you what that is. But Grant, thanks for your presentation. Just to clarify, I'm getting mixed up as to where the entrance. So this is the entrance to where the quarry is. So you basically go in that path and take a left along. Yep. Sorry.
so you come in, if you're coming from Spitalfield direction, you turn right in there, you go up, and then you'll go round to the left, and that's where the site is. So that's the only, I'm taking Mr. Booth because I've not been in on the site to have a look. That's the only way in and out. So all the movements will be out through that area onto the road, which is fine if it's kept clean.
Okay, thanks. I was up there the weekend actually and had a little look. I thought that the entrance was at the other end, but that does look more likely. Okay, thanks, Grant.
Bailey Ahern, you have a point of clarity.
Yeah, my understanding is that entrance is only to that site. It is not to the quarry. The quarry is further around the corner. Or is there a hidden lane between this site and the rest of the quarry?
Can you ask that question of officers when the time comes, please? That's great.
But that's what I'm saying. We've been told that it's the site to the quarry, but it's not. In the description we were given officers at the beginning, and from what we've heard from the community council, that is only the site to the part where they're doing the crushing from the tip. It is not the entrance to the quarry.
I think that's what Mr. Booth said as well, and I think we're all understanding that that's the only entrance. And now there used to be another entrance further round, which may be blocked off, but this will be the entrance to the site where the crusher is. Yeah, our officers could be up to the convener to give you the chance for clarity.
I think maybe what I can clarify is that the red line that's shown on the plan there shows how the site would be accessed from the public road. So at the minute if a vehicle was arriving with the screener or the crusher, it would go in via that junction up, deposit the screener and the crusher, and then leave. Okay, and that's what we're looking at. That we're not investigating how gathering of material is undertaken, how that is moved around, etc. We're simply showing this is where the machinery would be accessing off the main public road up to its location, deposited there, and then it would be used in situ. When that period ended, it would then be uplifted onto a vehicle and taken down to that junction.
Thank you, Mr. Smith. Councillor James.
Thanks, convener, and Grant. Councillor Lane, thanks very much for your deputation. I know exactly where you're coming from as one of the other councillors for Strathay Ward. My question really, Grant, is given that we are looking at a specific planning item for the location of that machinery, and given that we're being advised by our planning officers that it should be approved, and you know, it's very difficult to find reasons why we shouldn't approve it. Are you, as the leader of the council, happy that it would be defensible if it went to an appeal with the Scottish Recorder?
I think that would be more a question for somebody on legal or not. I have no planning. You've got more planning experience than I do. As everybody else at the committee, I don't think that's an answer, a question that is for me to answer.
I tend to agree with that. That's not a question that Councillor Lane could answer. There seems to be no further questions. Councillor Lane, you can join the then seat. Thank you. Thank you for your presentation. Right. This is a quasi-judicial committee, Councillor Lane. It's apolitical. Thank you. Right, members, do we have any questions for officers? Okay, Councillor James.
Surprised there, convener, right? And yes, please. Probably for Mr. Fogg. Sorry to put you on the spot, Jeff. But the question I just asked Councillor Lane about would you be confident if we've found a reason for refusal? Would you be confident of being able to defend that at an appeal to the Scottish Recorder? Thank you.
Councillor James, that's a difficult question to answer in the way you've put it, because you're saying, if we give you a motion, are you confident it would be successful in appeal? But you haven't said what it would be, which really is my problem in giving you a direct answer. All I could say is, based on the report, which identifies that this is simply for a further 2 years of an activity that has had 3 years, during the course of which there were not complaints. And I did think the community council representatives were very fair in saying that their primary concern was for the wider picture and less about this, and that there's less about this that's particularly of concern to them. It does lead me to a position where I think it's going to be difficult for this committee to advance a motion that is likely to have much prospect in being defended on appeal. I don't think I can say any more than that at this juncture.
Perfect, thank you.
Thank you. Councillor Waters.
Thank you, convener. Just in relation to the dust and the particular dust, and we've had quite a bit of information of people, deputations and that. But what I'd like to ask particularly is a lot of the information that was given over how dust is mitigated was on a visual part. But some of the most harmful dust is the very fine particulate dust, which carries easy in the wind and the air, and it's very fine. And can I just ask what information Environmental Health have looked at in relation to that and how it should be controlled on site? We've just been told that there's a condition in there, but it would be nice to have a bit more confidence in what we're looking at. To understand what that actual mitigation is and what we're looking at, and it's not just a visual inspection. There is something a bit more concrete in there, if that's the right word to use.
Thank you, Councillor Waters. Lynn, do you have an answer for that?
Yes, Councillor Waters. The dust management plan has to look at all the activities on that site that would generate dust, and then they have to come forward with mitigation measures which will reduce the level of dust being produced. So they also have to look at, as you stated before, a visual of what the weather conditions are on a given specific day, and then what measures they will put in place to ensure that dust production is controlled to a decent level. So that would be things like dowsing down on dry days and windy days, ensuring that the crusher machine, you know, the spray water is effective and is used, ensuring that the wheel washing is done before lorries leave the site, and also that they're covered, reducing heights when they're dumping into the lorries. So all that is included in the dust management plan.
Thank
Convener,
you.
Convener, can I ask a supplementary just on the same topic?
Very,
On the dust, yeah. Just the transporting, we know they should be covering it when they're leaving the site. When they're transferring the waste to the crusher from within the site, what's the regulations and rules around that? Thank you.
Well, again, but at that stage, it's solid slate. It's not until it goes into the crusher where then it gets crushed down, and then that's when your finer particles will be developed from there. Up to that point, it'll be dust over 10 micrograms probably.
Thank you.
Thanks.
Councillor Allen.
Thank you, Convener. I think my question has been somewhat covered there. I'm still concerned though. The main concerns, health and safety wise, of the local community are the silica and the silicosis problems. Are these byproducts, can somebody answer me, are these byproducts from crushing slate? Thank you.
Lynn.
Yeah. Silica is a crystalline silica, otherwise known as quartz, and it is found in all kinds of rocks, from sand, clay, shale, gravel, and silicosis is the occupational disease that people working in the industry can get if the appropriate health and safety is not implemented, and it's over a very long-term exposure to high quantities of this dust that cause the silicosis, and it is referred to as an occupational disease. My understanding is in the UK, I don't think there's been any silicosis being found within people living within quarry, but that might have changed since my last knowledge of it. But yeah, it's mostly determined as an occupational disease.
Thank you. Bailey Williamson.
Yeah, I think probably again my question's been partly answered, but I mean, one of the conditions that you were outlining, the minimising dust, but what does that actually mean by minimising the dust to what levels? And it feels from the objectors and the deputations we've received that there's been great storage put on the amount of enforcement action that's been taken or not taken. And I'm just seeking some reassurance that we are able to fulfil the obligations that have been put on the developer.
I think, you know, if you take a look at condition 6 that's recommended, it says adequate precautions to ensure that at all times and all stages of the process, dust generation on the site and out with is minimised by implementing agreed dust prevention measures. And as part of the process of producing that document, adequate measures would need to be defined and set out therein. But as we've discussed already, you know, various activities and analysis would be undertaken dependent on specific conditions as well, to ensure that dust wasn't being transferred beyond the boundaries of the site to any degree that would be deemed to be unacceptable in terms of relevant standards.
Sorry.
Could I ask about the enforcement action as well? Are we confident that we are able to provide proper enforcement?
Do that after another question. Bailey Brock.
Thank you, convener. And while we're looking at recommendations, I'm looking at recommendation 5, and I see the just for clarification, I wonder if this is normal or not, but the plant and equipment approved shall be limited to 0700 hours to 1900 hours. Is that a normal time? It seems quite late on in the evening, for especially the closeness to the residents roundabout.
Yeah, these are, and perhaps Lynn can step in if I don't get it exactly correct, but these are times that are related to when different types of noise limits in terms of various standards kick in. But I would maybe clarify as well that there aren't properties that are particularly close to where the plant is to be provided. I think 160 metres to the nearest property at the junction. There's also significant topography and things, and in terms of the properties at Dean's Park, it's multiple times that distance.
Thank you. Councillor Lane.
Yeah, I was just wondering if there's anybody from enforcement team here that we've dealt with over the last 10 years that could maybe fill in some of the gaps that don't appear in the paper.
Well, I'm here, Councillor Ling, and as you're aware, I'm the service manager that has overall responsibility for development management, including planning enforcement. So hopefully I would be able to answer any questions relative to the proposals before us.
Okay, can we go back to about 2013? And because a lot of the phone calls, etc., that have been passed on about actual quarrying going on and that, and I never got feedback really that somebody went outside because they saw peckers working and that sort of thing, creating more slate rather than just the spoil. I was just wondering if I
Councillor Lane, can you just stop there, please? Bailey Ahern, you've got a point of order.
I have. Councillor Lang is not a member of his committee. He has spoken on behalf of it and he's given up his right to speak anymore. He shouldn't be asking questions.
No, under section 1999, Councillor Lane asked my permission to speak at the committee, which I gave him. Yes, and also contained at 99 is permission for the person to ask questions of officers.
Okay.
I'll quote it to you. Any councillor who is not a member of the committee may, with consent of the convener, address the committee on any item of business on the agenda that affects their ward. That affects Councillor Lane's ward. The councillor shall address the committee prior to questions. With the permission of the convener, the councillor may ask questions, but they shall not be entitled to participate in the discussion or the vote on this matter. So they can't. Councillor Lane is allowed to ask questions, but not participate in the vote or the vote. Okay. Councillor Lane.
Thanks. I think I'd finished my question. I do find it kind of strange that there's nobody from enforcement here when a lot of enforcement information is quoted in the actual paper. People who would be directly involved on a case-by-case basis.
I'm relatively confident that I can answer the questions adequately, Councillor Lane. As you're aware, I've been involved in this case for many years now and have a good knowledge of the situation. If you feel that individuals need to be here for any particular reason, I could have arranged that, but I don't feel that that's necessary in looking at an application for the screener and the crusher that we're dealing with here. But if you have any questions in relation to the enforcement investigations in relation to that, more than happy to answer and give clarification on the position that we've taken.
Okay, I'll just register my disappointment that there was nobody actually who was dealing on a case-by-case and actually visiting the site. I don't know how often you visited the site over the last 11 years. Or if you were just getting feedback, as everybody here today is just getting feedback, not actually seeing what's happening on the ground. Thank you.
Thank you. Bailey McLaren.
Thank you, convener. It's just a general question to either Christian or Lynn. Again, Amona, with regard to the conditions, after these deputations that we've heard lots of concern about dust, is there any further conditions that we should be considering to add to this application, or are you content that actually these conditions recommended are robust enough for the concerns of the community? Thank you.
Thank you, Bailey. I think we're recommending the report to you and the conditions associated to it, and we feel that that's an appropriate means of controlling the proposal that's before us for the siting of a screening and crusher and its operation in relation to the collection of material that in itself is permitted development. All I can say is that I can't comment on behalf of the community and whether they would be satisfied, but the conditions in themselves are those that we recommend to you, and we are confident that they are the appropriate conditions in relation to the proposal before us.
Thank you. Councillor Waters.
I think Bailey McLaren's mostly asked the question, but just to try and ask on a specific element, and certainly in relation to the dust and environmental health on our monitoring of the site, what potential is there within there to kind of enhance the conditions over that and I know it puts an onus on the council as well in environmental health to actually keep monitoring the site, because a lot of the concerns from the deputies and the locals is health. Genuine, and you understand perfectly if somebody's next to a quarry and they're waking up in the morning and find dust on their car or wherever, there's a real concern. And we've asked the contractor as well about it. But is there anything more we can do as a council within the planning guidelines to actually sit and say, ask for a continual monitoring or something where there's an external element just to confirm that the right mitigation, not conditions, but the outworking of the mitigation conditions is actually happening on a continual basis rather than a continual stream of people reporting. Thank you.
Lynn?
Yeah, can I just say that this is, there is 3 different applications for this site. So the main quarry site, we have asked for monitoring to be undertaken as part of their dust management plan for that site, but for this site it wasn't deemed necessary because of, one, the distance to residential, and the controls measures through the dust management plan would be sufficient enough to ensure that dust is controlled and mitigated. And plus that we had never received any complaints with regards to dust from the existing operations of that site.
Sorry, convener, but can then we then add that condition into this planning application, that this part of the planning application that's in the other one, that there's a continual monitoring of the dust?
That could be easily part of the dust management plan in itself.
Yep.
So we already have that condition, and I will note your point, and in dealing with the methodology and things associated to that, environmental health can ensure that obviously you've got the applicants and their agent here today as well that will be producing the management plan for our consideration and approval. So I'm sure that monitoring actions can be incorporated into that. Yes.
Thank you. Are there any further questions? Oh, Councillor Allen, you've got a question or comment. Comments, you'll get an opportunity to comment later on, but do you have a question?
It's basically just following up from Councillor Waters there. I see at recommendation 6, it does cover the fact that we're going to have a dust management plan. I'd just like to reiterate that given the concerns we've heard from the community and from Councillor Lang this morning, that we're quite robust with that. That's my point. Thank you.
Councillor Lane.
Thanks. It's really a point of clarity because I understood Councillor Waters asked for it to be formally included, and I've heard Mr. Smith's answer, what's saying it's partly there. I think he's talking about it being robust. That was on recommendation 6, same as what Councillor Allen said. I think he's asking if it can be actually stipulated in there that there will be constant monitoring. But Councillor Waters will maybe, I misunderstood him at this end of the table. But that's what he said, and then Mr. Smith's answer didn't seem to state that, but said in some other way it would be happening.
No, maybe to give some clarity, Councillor Lang, if you look at the second last sentence of condition recommended 6, it says the plan shall also provide details of future monitoring and reporting on the successfulness of the plan. So I feel that there's a very robust position already recommended to the committee today.
Okay, thank you. Councillor Waters may want to comment. It doesn't say, future monitoring. Could be looking at it once every year and a half. Or once every 3 years, or whatever. And give a specification of what future monitoring means.
The detail of the monitoring regime will be set out within the dust management plan, and the methodology of that will be required to be approved by environmental health, and it will specify what is considered to be an appropriate and robust means of monitoring. But I don't. If you feel that the condition should say monitoring shall be undertaken at a specific measure, then that may limit the ability to do it in a way which meets with appropriate methodology. I'm not sure what more can be done to set out that we will look at an appropriate methodology for future monitoring.
Yes, and I'm not sure what you mean by your one, so we'll never understand what each other mean.
Councillor Reid.
Yeah, apologies. I thought I'd put in the question a wee while ago. I'm going to sort of labour this point a wee bit. In recommendation 6, it says prior to the commencement of the development hereby approved. My understanding, and I might be wrong, this is a continuation of an application of the process which is already ongoing. And there must be a dust management plan which has already been going for the last 3 years. Are we aware how robust that dust management plan has been in being policed, and how the new management plan will differ from the old management plan, assuming there is an old management plan?
What we're looking at here is an update to a new activity that will be undertaking. So the development ceased last year, and we've been looking at a new proposal before us for, yes, a similar continuation, but it's a separate planning permission subject to its own bespoke conditions reflective of its own merits. So it's a separate, yes, I understand where you're coming from, that it's a continuation of the processing of the material, but we've looked at it afresh and we have a revised approach to that, taking account of many of the comments that have been submitted to us and the experiences that we've had.
So is the old dust management plan available for people to look at?
The file is available for people to look at, yes. It's online and is there. All the conditions in relation to that are set out there and the information is available, yes.
In detail?
In relation to the information that's available in the file, that is there.
Thank you. Councillor Waters.
Yeah,
Thanks, convener. Just another same topic, obviously, but just another question on what happens once a dust mitigation, plan has been agreed with environmental health and that, what's our involvement then as a council from the planning perspective on monitoring that plan is implemented to the level that the council has agreed, you know, pre the committee seen the plan. Simple question, actually.
Sorry, can you repeat that?
Sorry. I'm just looking to see what happens after. So once the dust mitigation, once it's all agreed and it's implemented, if this committee was minded to approve this, what happens after that for monitoring it from the council's perspective? You know, are we just waiting on people complaining to sit and say they've got dust on their cars, or is there anything more active that we're doing to ensure that any proper dust mitigation is actually implemented on the site, and it's not just create a plan and yeah, that plan looks good, that we're actually ensuring that over the next 2 years, if we're minded to approve this, that it is actually implemented and it is happening on the ground, and the distress to residents in the area is minimised to the absolute most that it possibly can be.
I think maybe to give some comfort, you know, as can be seen from the report and some of the discussion, council officers have been at this wider activity area many times over the last decade or so, and we are monitoring it very closely. The condition also will set out how reporting and things is to come to us, and that will be reviewed and analysed. But I would expect that certainly, yes, officers will be visiting this site at various points in the future to monitor how implementation of the various aspects is being undertaken.
And that kind of covers the real concern we have, that there seems to be this ongoing thing that residents have raised, and that we are seeing through this committee, that there's this ongoing need to continually to keep doing that. So does that mean the mitigation that's getting put in place is enough? That there's a continual revisit in this on a regular basis, or is there something more that can be in there to try and raise the standards from dust pollution within the area? And that's the concern, and that's what I'm not yet convinced about with the stuff that's coming forward, that we've got this where you're sitting saying that the residents are kind of saying there's a clear issue that they're seeing in the area, and we're saying, well, here's the dust mitigation, and that's kind of already operating, but it doesn't seem to be working. So what more can we do as a planning committee and as a council to ensure that the standards are raised, so that we don't keep seeing a repeat of these issues going forward?
I think, you know, what I would focus in on is what we're dealing with today is the siting and use of a screener and crusher. The information that we have in the view of environmental health is that there aren't issues associated to dust in relation to the operation of that. There's been a lot of discussion in relation to other aspects of activity in and around this locality where there are significant slate waste deposits, and that there may be issues associated to dust migration associated to that, but not in relation to the proposals here. I'd also direct you to paragraphs from 29 in the report, which sets out some of the complaints that have been made, and many of them have been found not to be breaches of planning control. But you know, going back to your maybe focal point, monitoring has been undertaken and will be, and there will be controls in place that will require feedback in relation to the dust management plan to set out how the mitigations have managed themselves over time. But officers will be visiting this site, I have no doubt of that.
Thank you. Councillor Lane.
Thanks. Sorry to go on about this, but it's again about clarity of monitoring. Mr. Smith said that there is a file somewhere that would show us. I'm sure the officers have dusted it off. We're knowing that this was coming to committee today, and they would be able to tell us how much monitoring, how many visits that were not prompted by members of the public, how often it was looked at by whatever team within the council looks at the monitoring of dust over the previous period, and that would give us confidence knowing that it's set up in such a way that moving forward over the next 3 years it will be equally as robust. So I'm sure that file that you referred to earlier was looked at.
I think the file that Mr. Smith referred to was the planning application for the original sighting of the screening.
Sorry, convener, you said it was a file that would refer to monitoring of the dust mitigation measures. That was when he was talking about a file.
Yeah,
I think it was a dust management plan. I think I was asked if there was a dust management plan associated to the previous permission that allowed for the screener and crusher to be used. In answer to that,
No, I think it was from Councillor Reid, and he asked if there was a previous file and they had monitoring. He was wanting to look at that file to see how the monitoring had been carried out. And your response to Councillor Reid was, there is a file somewhere.
That was not my understanding of what was said. Councillor Reid asked the question, is there a previous dust management plan put in place on the first application? Mr. Smith said there was. So if you look at the previous application, the dust management plan will be there. The monitoring, I never heard Councillor Reid mention monitoring. I heard him ask about the plan. I never heard him ask about monitoring.
Sorry, I mean, Councillor Lang's extrapolation of that is one that, if I were more articulate, I would have done as well.
Councillor James, you've got a point of clarity.
Yeah, so I think you pretty much summed it up then, to be honest, convener. But I think we're drifting into operational matters rather than planning matters, but thank you.
Thank you. Any further questions? No further questions? Councillor Lang, you're free to go to join the. Thank you. Thank you. Can I ask for a motion? Councillor James.
Yeah, thanks, convener. To be honest with you, I have sympathy with everything the Dunkeld and Burnham Community Council representatives had to say. Complete agreement with pretty much everything that Councillor Lane, leader of the council, has mentioned today and questioned. However, we're here for planning, and I'm very, very conscious that anything that we do would itself be subject to scrutiny by the applicant. Therefore, I would move the paper as is, convener, in the knowledge that if we were to refuse, it would go be a subject of an appeal, and our record on appeal to this sort of development isn't good and at a cost to the council. So I'd move as is. I think there's been a lot mentioned of the dust management plan. I think that is covered in the conditions set out in the paper, and I think it's covered. Okay, thank you.
Councillor James, can I ask you're prepared to move the paper that's with the amendment to a condition 1, include the amendment to condition 1, which Mr. Smith stated at the beginning?
Sorry, convener. Yes, that's
right.
what
Thank you.
Yeah,
thank
sorry.
you. Now I'll just go to Bailey Ahern. You want to second that motion?
Yeah, I'm not going to add anything else. I'm just happy to second.
Thank you. Councillor Waters, you have a point of clarity.
Yeah, just before decide on an amendment, just to add to from a legal perspective in relation to you know, we clearly within LDP2 so policy 57 a clear obligation on air quality and stuff like that. If we were to go for a refusal and you know, given I understand there's a condition in there for the dust management plan, but if we were to go to a refusal, because I don't know what that says and what the relative, how much it is, what's in that, and to at this stage to go for a refusal based on policy 57 LDP 2 and ask the applicant to come back with actually far more details on how they're going to improve mitigating the dust issues that have clearly been identified around the site. Thank you.
Convener, I find that difficult to answer, Councillor Waters. Essentially, as I understand it, you're asking about the prospects of this being refused on the basis that it is viewed as a contravention of policy 57 of LTP2. In that regard, I can only state again that most of the activity in terms of the extraction and transporting of the slate is permitted development that's not before us and will be happening in any event. This is simply the screening and crushing. It has been operative for a 3-year period, and I don't think you've had clear evidence from any party yet to suggest that air quality is at a level that it couldn't be further extended or approved for a 2-year period. There's not been an objection by the HSE, there's not been an objection by the internal environmental health. Ms. Reid has addressed it something like this morning. She's not expressing concern in relation to air quality. The nearest property that I'm aware of is in the region of 160 metres. I know that compares quite favourably with Marley Quarry, where they were very, very much more closer, and the council, as has been stated by Councillor James, were unsuccessful in opposing that development when the houses were less than half the distance, closer than 80 metres. This is quite a substantial difference to the nearest house, which itself has not complained, as Councillor Lane confirmed to you this morning. So adding all that together, I don't see a basis in which there would be a valid basis for resisting this development on the basis of policy 57 of LDP2. I'm sorry.
Thank you.
Thank you. Can I ask if there is any amendment? No amendment. May I ask if members have any comments on the report? No comments either.
Sorry, can I just come in? You know, I do hope with this that the contractor will take seriously the mitigation, and you know, when this dust management plan comes in, they will look at trying to, you know, ensure that it tries to mitigate to the maximum possible level the amount of dust that's generated through the activities of the screener and crusher, and the officers will ensure that highest level within the dust management plan is looked for as a council, and that the contractor ensures that level is followed throughout to minimise any disruption for individuals staying close to or around the quarry. Thank you.
Councillor James, as the proposer of the motion, you're unable to comment on this. Thank you. As there is no amendment, planning permission is therefore granted with the inclusion of the amendment to condition 1. Thank you. We will now take a comfort break of 10 minutes. Thank you. Okay, welcome back, everyone. We now move on to item 512, which is the change of use, alterations and extension to workshop to form dwelling house at Rowan Garth, Fortingall. And to introduce the report is Mr. Williamson. Thank you.
Thank you, Convener. The next item for consideration today relates to the conversion, alteration and extension of a traditional building last used as a workshop in a small hamlet at Garth near Fortingall. The proposal seeks to create a 5-bedroom property over 2 stories of accommodation. This application has been referred to committee in light of the receipt of 12 letters of objection to the proposal, including 1 from the Glen Lyon Community Council, as set out in section 23 of the committee report. In general, the reasons for objection related to the perceived conflicts with the development plan and land use, visual and residential amenity, traffic impacts, trees and ecology, and also drainage. Other aspects, which are civil matters such as maintenance and scaffolding requirements, are not material planning considerations. As outlined within the report, the broad principles of the utilisation and conversion of this traditional property is encouraged through both the National Planning Framework 4 and the Local Development Plan. Therefore, subject to conditional control, the application is recommended for approval. I will now take you through a short visual presentation to set the scene. As shown on the screen, the grouping at Garth is located eastwards of Fortingall on the C448, a short distance north of the River Lyon. The site is in a relatively secluded location from the public road, but in close proximity to a number of other properties in residential use. Next slide, please. Here we see the location plan showing the red line site boundary extending down to the public road and the wider treed landscape to the west of the former workshop. Next slide, please. The site plan shown now illustrates in slightly more detail to the respective relationships to adjoining property. Next slide, please. This additional aerial extract seeks to show the footprint of the former workshop and subsequent extensions, and the narrow nature of the intervening track leading northwards and northeastwards. Next slide, please. Members shall now see the proposed alterations to the property, with the left-hand side showing how the roof pitch would be increased to cater for additional accommodation at first floor level. On the right are the floor plans, which show the majority of living accommodation on ground floor, together with one of the bedrooms, where the first floor would comprise 4 bedrooms, 2 of which would also have ensuite facilities. Next slide, please. On screen, we now have more detailed elevations. Top left is the roof plan, which shows the intended roof lights. Of particular relevance are those along the eastern facing roof plane. In order to protect residential amenity to the east, condition 5 would seek to have these windows frosted, obscured or opaque glazed in perpetuity. Next slide, please. Lastly, we see the sections which illustrate that some views eastwards may be possible, although there is a change in scale and height between the proposed and existing properties. But again, this would be protected through the use of the glazing condition previously outlined. I shall now run through some photographs of the site. These first photos show the affected building on the left and the adjoining neighbours building on the right-hand side. Next photo, please. Here we see the south and west elevations of the host building with its traditional form of stone walls and slate roof. Next photo, please. Next, we see the east elevation on the left and the north elevation on the right. As part of the proposal, these roof forms would be removed and replaced with a mansard-style solution. Next photo, please. Here we see the view north between the properties to the south, with the host property just visible on the left-hand side and other residential properties to the right. Next photo, please. Lastly, we see the separation between the properties in more detail, giving an appreciation of the relationship between each. Next slide, please. Thank you, members. That now concludes my presentation, and we now return to the site plan.
Thank you, Mr. Williamson. We have deputations on this. I'll now hand over to the Vice Convener for the deputations procedures. Thank you.
Thank you, Convener. I believe we have on the telephone Ms. Dolan Bettany. Good morning. You will have to *6 your phone to unmute.
Hello?
Good morning. Is that Miss Dolan Bettany?
It is.
And you're representing Glenlyon and Lochte County Council and you're objecting to this application?
Yes.
You have 10 minutes for your deputation. I'll give you a prompt after 9. So whenever you're ready, please start.
Thank you. Good morning. Yes.
On you go, please.
Thank you. Just by way of introduction, this is the longest running application in the life of the Community Council. 17 months to date, with no explanation for the year-long silence. However, access, this has been a major objection.
Sorry to interrupt, Mrs. Dolan Bettany. Is there a radio or a television in the background that's interfering with our hearing of you?
Of course. Is that better? I'm struggling because what is on the screen and what I'm saying are not in sync. Never mind. Access. This has been a major objection from the beginning.
Sorry, Ms. Dolan Bettany. Have you got the live screen on of the committee?
I've got the live screen on.
You need to switch that off, please. Put it onto silent. We're getting feedback.
Right. Is that better?
Thank you. I'll reset the clock and if you restart, please.
Right. Thank you very much. Yes, just by way of introduction, this is the longest running application in the life of this Community Council. It's 17 months. And there's been no explanation for the year-long silence. However, access. Access has been a major objection from the beginning. The overhang of the roof on the eastern elevation would have blocked the right of access along the Vennel, which is the only way to reach the two properties at the top. And the intrusion of the northeast corner would have prevented vehicles turning at the top of the Vennel and the farmer's access to his fields. Following an inquiry by an elected member on behalf of the Garth residents and Community Council, superseded drawings appeared in the public domain in January this year and were treated very much like a new application, with the public being given 21 days to comment. Contrary to the report of handling, the roof changes were not subtle or small. The northeast corner has been reconfigured to remove the protrusion into the Vennel, thus solving the access problem there, but the overhang on the eastern side still remained. That required another intervention by an elected member, and more drawings appeared in February. The picture of the eaves on the east side has been altered, just removing the overhang on that side. There is a right of access along the Vennel for three properties, fields, and the water house for the Garth water supply. We feel it cannot just be brushed away as a private matter, as the report of handling states. The very changes that have been made to the roof testify to this being recognised as a planning matter. 24/7 vehicle access is required, and any disruption along or across the length of the Vennel is unacceptable, be it use of scaffolding, fencing, or anything else. The Land Reform Scotland Act 2003, Part 1, Section 1361 states, this section places a duty on local authorities to uphold the exercise of access rights so far as doing so is consistent with other functions, etc. It goes on. The Community Council respectfully asks for a planning condition that reflects the upholding of the exercise of rights of access
for those who hold them. Surface water drainage. Community Council has asked repeatedly for details, but has never had a reply. There is no mention of surface water drainage anywhere in the application. There's a one-liner in the report of handling stating it will be by soakaways within the site, and that's all. Therefore, again, the Community Council respectfully asks for a planning condition that requires that before building commences, drawings be produced that show the siting of soakaways. In part, the reason is that the bottom flat in the building immediately south and downhill of Roundgarth flooded after it was renovated due to inadequate surface water drainage. The occupants could not get help from planning enforcement because it was said there was no condition in the decision notice referring to surface water drainage. We don't want the same situation to happen again should the soakaway prove inadequate and flooding occurs to the flat or the West Drive. Having asked for 2 more planning conditions, the Community Council would rather this application was refused altogether. The development doesn't comply with Policy 1A. It does not contribute positively to the quality of the surrounding build. The design doesn't respect the character or amenity of Garth or sensitivity to its history, being a modern design in the very midst of the old estate cottages and close to 2 listed buildings. Contrary to the report of handling, it would introduce the incongruous feature which would be detrimental to the visual amenity of the Garth estate. The mansard type roof in particular is an oddity. They are not recommended in areas of extreme weather, we understand, and hence are not common in the Highland area generally, and in Garth, they're completely out of place. The eaves are drawn on the plans to look like slate, but on the plans, the top sections look all of a piece, and we've no idea, we don't know what they're to be made of, despite having asked. And whether the subtle amendments, as report of handling calls them, have improved the design is a matter of personal opinion. The roof is an incongruous feature. The building is too big for the site. Some of the original stone walls have been retained. It's what is above them that is out of keeping. The new upper floor adds considerable bulk, the mass, causing it to dwarf the site, and not all the ground on the north side is available as amenity space. Some of it is used as essential turning space. The reduction of natural light to adjacent building is considered in the report of handling as minor. It is not minor for the people who will suffer the loss of over a quarter of their light, especially during winter. That's depressing. And there's still the right of access consideration. Taken all in all, we ask you respectfully, please, would you refuse this application? Thank you.
Thank you, Ms. Dolan Bettany. Are you willing to take questions from members?
Yes.
Okay, if you give it a moment while the chat function populates. Bailey Williamson.
Thank you, Deputy Convener. My question is about, Sue mentioned a couple of times about the soakaway. Are you saying, Sue, that the soakaway is at capacity as it already sits, or it can't cope with anything further going in there?
Well, we don't know. The ground is known to have a high water table, and Garth is notorious for flooding, and we don't know. On the east side, there are downpipes which go into a drain in the Vennel. It's on the west and the southwest corner. There are now downpipes which, we've had no idea where they were going up to the report of handling, saying they're going into a soakaway. As far as I know, there are no soakaways actually on the site at the moment. the existing roof drains into the drainage in the Vennel.
Bailey Ahern.
Thank you very much, and thank you, Mrs. Dolan-Bettany, for your presentation. You mentioned a couple of times about the roof and the potential overhang into the Vennel, and you mentioned that the roof design was changed twice to get rid of that. Are you now happy that the roof design no longer constitutes an issue with regards to obstruction over the Vennel?
Yes.
And Sir Alan. Ms. Dolan-Bettany, there appears to be no further questions, so you're free to go.
Thank you.
Thank you. Can I now call on Ms. Polakowska, objector to the application? I'm sure you're aware now that you've got 10 minutes for your deputation. I'll give you a prompt after 9 minutes. So whenever you're ready, please start.
This morning. Good morning, ladies and gentlemen. Just to explain, I live just above, I live at Garth, just above the proposed site, with a clear view of it in one of the two listed buildings at Garth. The applicant bought this site with planning permission for a 3-bedroomed house, and there were no objections to that application, none whatsoever. And I would request that the applicant is advised to revert to that 3-bedroom plan, which must have seemed adequate when he bought the site. That plan retained the original features and the character of the building, including the attractive slate-covered roof, which I see very clearly from my home. The building is in scale at the moment with everything around it. The applicant has lived in a flat at Garth for over 6 months, lives alone and has no need for 5 bedrooms. The proposed 5-bedroom house can't be built without scaffolding, blocking the narrow Vennel to the east of the building, which of course the applicant doesn't own. And in fact, his access rights are disputed to the Vennel. The Vennel is the legal and only access to 2 properties, including my own home where I live with my husband. The other property is yet to be built. The owner is awaiting has planning permission and is awaiting an amendment so that he can start building, which obviously blocking the access would not be appropriate for. We have a legal right of access through the Vennel, and our access cannot be blocked. The Scottish Government states that it is the duty of local authorities to uphold access rights. We will insist on our access route being kept clear at all time, and it's not reasonable to leave my husband and I without emergency cover. Scaffolding would prevent emergency vehicles from reaching our home. I think this is a very important point. Our business involves regularly transporting fragile, often quite heavy goods to and from our place of work, so vehicular access is essential. If the Vennel is blocked, we couldn't receive post or any deliveries, including essentials such as heating oil or logs. The applicant has been working on a neighbour's house at Garth, where his scaffolding has been in place for around 12 months, and it's still there today. The farmer who owns fields above Garth was not on the neighbour notification list. He has the right of access to his fields through the Vennel and then along the track beside the north wall of the building, just behind the building. In order to turn the corner with a tractor or trailer into the north, behind the north side of the building, it's necessary to drive over what is referred to as amenity ground on the north side of the building. You'll notice on the plans that the northeast corner is cut to facilitate turning. Number 4 Garth Cottages is to the east of the site and has access rights to the Vennel. Part of their property has an entrance at the north end of it. The owners have told me that they will not give permission for their access to be blocked. The Garth Water House is in the fields above Garth, and it houses a tank for the private water supply used by 6 properties, all with right of access through the Vennel, which can't be blocked in case of problems with the supply. The Victorian system is fragile and does include old lead piping. The walled garden has a right of access through the Vennel. It has flooded in the past due to blocked watercourses on the north side of the property and could require a digger in an emergency. The proposed building forms part of a group of traditional properties located between two listed buildings. These form part of the heritage setting of B-listed Garth House, which is confirmed in the report of handling. The scale and style of the proposal does not respect the surroundings and would certainly detract from the visual amenity. I believe it's important to retain the integrity of our built heritage. Buildings at Garth, which are not in traditional style, are out with this main group. The height of the proposed building would dwarf its neighbour. The current roof is a sort of very distinct two separate sections, whereas this is a big flat block on the top. So its neighbour, Fourth Garth Cottages, and some of the proposed materials, for example, the timber cladding, are not appropriate in this setting. The statement that the roof is natural slate is misleading. Presumably, the greater portion of the roof, the flat parts, would be made from an artificial substance, as slate can't be used for flat roofs. The architect has not specified what this substance might be, which is worrying as it'll be highly visible from our own listed building. The present natural slate roofline is very attractive, and I suspect that the large flat mass will be ugly. We will also see the large glazed areas on the north side of the proposed buildings from our home, where light pollution could reach the field, affecting wildlife. Dark skies have always been one of the pleasures of Garth. The mansard style of roof is well known to be unsuitable for areas of heavy rainfall, which we certainly have. This type of roof will look very out of place beside the traditional ones surrounding it. And I also believe flat roofs are not good where there can be very heavy snowfall. We can have snow lying to 18 inches, which is 46 centimetres or more than that. It's been accepted that the proposed building is over large for the plot, and it should be pointed out that what is referred to as amenity space on the north side of the building cannot be used as such. A tractor turning into that area takes up most of the width of the so-called amenity space to make its turn, so you wouldn't be able to have plants or fencing, for example. It's really quite a small piece of land and quite separate from the rest of the plot, in actual fact. The turning area is used regularly by the postmen and delivery drivers who reverse into it to enable them to turn down the into the narrow Vennel. The 3 cars, this proposal for 3 car parking spaces, they would take up most of the space in front of the building, and it's not specified how these cars will turn. And any amenity space is truly minimal. There is really practically nothing there. The serious issues and problems which this development would cause, only some of which I've mentioned here, would directly affect people's lives. I would urge you to reject this application and advise the applicant to go back to the approved plan for a 3-bedroomed house, which was in place when he bought the site, and no one had objected to that. If you choose to ignore the wishes of the majority of Garth residents and approve these plans, I request that you apply a planning condition to protect the rights of access through the Vennel. Thank you.
Thank you for your deputation. Are you willing to take questions from members? We'll give it a moment. Bailey Ahern.
Thank you very much, and thank you for your presentation. You mentioned a couple of times during it about the original plan for the 3-bed property, and you also made heavily on the access with scaffolding that would have been in the narrow road approaching your properties. Would there not have been scaffolding for the 3-bed property?
I beg your pardon. It wouldn't have been necessary for a 3-bedroom property because it was retaining the original roof in style and everything. It's only necessary for this mansard style roof. And so the 3-bedroom property would be acceptable from all points of view.
Councillor Allen. Bailey Williamson.
Thank you. Jackie, you've mentioned a number of times about the Venel getting blocked. Is this because of the overhang on the roof, or are you more concerned about the scaffolding during the construction phase of the development?
Sorry. The problem with the roof overhang has been addressed. It's purely because of scaffolding. Apparently, this building cannot, the style of roof, it's not possible to build it without scaffolding blocking the Venel. And as the applicant doesn't own the Venel, we believe he doesn't have rights over it, and nobody will accept the access being blocked. We can't be left without emergency services. We have open fires. We're an elderly couple. It's not reasonable to block our emergency access, or access for anything else for that matter. But I think it would be a period of time it would have to be blocked for, and that's why the 3-bedroomed application, which the applicant allowed to lapse, would be more appropriate, more suitable in this situation, and not cause problems to the people round about.
So you're just really concerned about the Venel basically being blocked for a temporary time during the construction phase of the building?
Yes, that's correct.
Councillor James.
Thanks, Deputy Convener, and thank you, Ma'am, for your presentation today. Very well thought through. You mentioned the Venel and the potential building not having permission to use the Venel or ownership of it. Do you happen to know who actually owns the Venel? Only reason I ask is because you would probably have had to have that to build your property if you access through there. So is it in your ownership, or yours and your neighbours maybe?
No, I don't own it. My building is an old property. It was built in the late 19th century, around 1900. The ownership is, I believe, disputed. It's either owned by number 4 Garth Cottages, who claim they own it, or else it's owned by a property developer, who's not the applicant.
Appears to be no further questions, so you're free to go. We have a deputation from Mr. Young, and it'll be read by the clerk, Miss Gould.
Thank you, Vice Convener. This statement is read on behalf of Tommy Young, who cannot be present today. You are already aware of the numerous local objections to this long-standing application. I am writing to request that the above planning application 22018868 FLL be taken off the agenda for the April meeting. Some, though not all, reasons are documented below. Only when answers are received on these points, and only then, can the committee make a proper, fully informed and fair decision on the matter. Reason 1. Since the date for comments to be received was 19th of February, a further 7 documents have been submitted by the applicant. However, interested parties were not given the chance to comment on these as they should have been. Due process has not been followed. Reason 2. A major piece of new evidence since the 19th of February has been the introduction of a mansard roof. This has appeared from nowhere and is not in any of the documents produced by the applicant. It has only ever been described as such by the case officer in the report of handling of 3rd of April 2024. As you can see from reading the objections, the roof in this application is a major issue. This matter requires that interested parties have the chance to comment. Due process has not been followed. Reason 3, the handling of this application is strongly questioned in that no explanation has ever been given for the year-long gap between the deadline for receiving comments on the 8th of January 2023 and new documents being added on the 15th of January 2024. In each case, interested parties were forced to respond within 21 days. The applicant took over a year to come up with a response to the comments, but this only resulted in even more objections. Due process has not been followed. Reason 4, there are no dimensions or reference points on any of the drawings supplied by the applicant. There are also inaccuracies in the report of handling with ratio of house to amenity space to plot size. Therefore, nothing can be checked, confirmed, verified or otherwise. What would the committee be approving? The application is therefore incomplete and lacks basic information to make an informed decision. Reason 5, from the BAT survey, the applicant cannot commence work between the 1st of April and the 30th of September. So why the hurry to conclude when there are so many outstanding questions to be answered? Due process is not being followed. I could detail far more that is wrong with this application, but I will close by urging you all to read the objections submitted by those who are actually going to be negatively affected by this proposal. End of statement.
Thank you. Can I now call on Ms McQueen and Mr Sturrock, agents on behalf of the applicant, and they'll be joined by Mr Brown, the applicant. I'm sure you're aware you've got 10 minutes each for your deputation, so whenever you're ready, I'll just start the clock.
Thanks for your time this morning. We're here in the main to take questions, however, I think there's maybe a few points to clarify. The applicant does live on his own some of the time, however, he has 3 children he has to provide for, and this is a family home for Mr Brown. In terms of the surface water, as noted, there is a previously approved application on this site for a 3-bedroom home. The footprint for that proposal with the hard standing is 165 square metres. The footprint for this proposal, along with the hard standing, is less at 152 square metres. In terms of the foul water, a drainage engineer would need to be appointed at building warrant stage, assessing the existing system, where we'd need to demonstrate if it's suitable to take any additional load. If not, we need to compensate for that. This would all need to be to SEPA's approval as well as Scottish Water's. In terms of the access, and as noted on the drawing that's on the screen, every drawing that's been submitted does have a scale bar and an annotation on as per PKC's usual guidance. I think the point on the roof being cut back to the vennel has been addressed and acknowledged by the objectors. In terms of the access on the vennel for scaffolding, Mr Brown will maybe come in here, but he has confirmed that it is possible to build this development without the need for scaffold on that vennel. I don't know if you want to come in just to maybe advise on how that can be achieved. Yeah, of course, yeah. Yeah. In terms of the access being maintained by no scaffolding within the vennel, we're happy if it is possible for this to be conditioned in any way, but I'm not sure if that can be. There were comments on the area to the north. The area to the north, as seen on the proposed scheme, is the exact same as shown on the previously approved scheme. There's no change to the access in that area from what's been approved previously. And that's all the comments I've got.
Ms McQueen, are you wanting to make a deputation? Are you happy? Okay, are we going to proceed to questions if you're willing to take questions? Okay, I wasn't aware that the applicant was going to make a deputation, but we're happy to hear a deputation from Mr Brown, or we can move to questions. Okay, yep, please, yep.
Still good morning. Yes, it's a first floor slated side roof. It can be initiated off ladders, but if we were forced to, we could build up the roof from the gutter level from inside the building and work that way. And then from that you can work on slate spikes. There's no need to have scaffold there for any time.
Okay, are you willing to take questions from members? So we'll give it a moment while the chat box gets populated. Amelia Hearn.
Thank you, and thank you for the presentation. I just want clarity on when the changes were made to the drawings regarding the roof, because we heard in the written objection there that after the date of the end of the consultation, there were changes made to the drawings in terms of the Hansard roof. But in previous objections, we heard that there were two changes that they were aware of, and they were then happy with the final drawing. And I'm a bit confused how one person wasn't able to see the changes, but the other objectors were and were happy with the final outcome. So could you tell me when the final change was done to the drawings? Was it after the consultation, or was it prior to the close of the consultation?
It's always been a mansard roof. It's always been a mansard roof, but the changes were made during the second submission of the drawings. We changed the eaves detail due to comment from Councillor John Duff. So as a result of that, to try and help with the concerns of the objectors and to make the Venel easily accessible, we then brought back that change. But all the drawings were on the portal to be viewed by the objectors.
It's maybe a question for Mr. Williamson later on. You might be able to pick up on that.
Councillor Allen.
Thank you, Vice Convener, and thank you for your deputation. Just a bit of clarity really on something that you said. The previous 3-bedroom house that was approved, did you say that it was 168 metres square?
We've reviewed the footprint of the previously approved building, as well as any hard standing. When it comes to the building warrant side of things, any area that collects surface water needs to be accounted for. So that's roof covering and hard standing. There's a large area of hard standing on the previous approval. I think the previous footprint of the house was 135 square metres. However, there was a 30 square metre terrace, which took it up to the 165 square metres. We've reviewed our proposals and we have 152 square metres, which includes a small area of hard standing.
So there was also a complaint about 3 parking spaces and there's no space for that. Can you address that for me, please?
Yeah, I think there's a larger site plan drawing that shows it. The application's obviously been submitted and sent for consultee responses within PQC, and there's been no objections raised there. We do believe that it's suitable for 3 vehicle spaces and turning and exiting and forward gear.
There appears to be no further questions, so you're free to go. Convener, there's no further deputation, so I'll hand back to yourself.
Thank you, Vice Convener. Can I ask members if they have any questions for officers? Bailey Ahern.
Thank you. It's in relation to the last question I asked the applicant there, and that was clarity about when the changes with the roof were made, because we had one objector saying he didn't see the changes, yet we had 2 other objectors saying that they were aware of the changes and then were happy with the final change. That doesn't correlate, so I just want to know whether all the changes were made and there were no changes to the application after the close of the consultation.
Thank you very much, Bailey Ahern. Yeah, certainly the application drawings were amended in the middle of January, obviously due to the nature of the changes showed therein. We went out and re-notified on those plans, followed due process that ran through until the 19th of February. There were plans which were received thereafter, which were basically picking up on the fact that some of the elevations, etc., hadn't been included before, didn't fundamentally change the scale, proportions, etc., of what was being proposed, and we were satisfied that we did not require to undertake further notification on that basis. So the affected parties have had the full opportunity to comment on what's being proposed.
Councillor James.
Yeah, thanks, Convener. And mine's quite a simple one, really. The Venel seems to be, the contentious issue and access. Am I right in thinking that the Venel isn't included within this planning application? So therefore, it's a private issue rather than a planning issue.
Thank you, Councillor James. Yes, that's 100% correct. It's not in the red line site boundary and it's a private matter.
Councillor Allen.
My question may have just been marginally addressed. Given that the majority of the concerns, apart from the roofing, are about the Vennel and access, is it something that we should condition that there is no scaffolding and therefore access is clear at all times?
Thank you, Councillor Allen. Obviously, it's land that's not in the control of the applicant, so it would not actually be responsible of the council to apply conditions on land that's not in their control. And obviously, we have heard from the applicant today as to how construction techniques could allow it to take place without the need for scaffolding. So it would be excessive, in my opinion, to seek to condition such a matter.
Thank you. Any further questions? No further questions. Can I ask for a motion? Bailey Williamson.
Thank you, Dr. Convener. My motion is for rejection. I don't believe that the mansard roof is a appropriate design solution, and it's not of a traditional Scottish design. I think this conflicts with policies 1A, 1B, and policy 17.
Are they all on the LDP? Yeah, thank you. Do I have a, I do have a seconder. Councillor Waters.
Happy to second. It doesn't fit in with the other houses within the area, the type of roof. Don't need to say more than that.
Thank you. Councillor James, you have an amendment?
Yes, Convener, and sorry to go against Mike. I know that this will be in his ward, but looking at what our officers put in their report and what we're actually being asked to provision for, I would accept that we accept the application with the conditions as proposed by our planning officer. Thank you.
Thank you. Can I ask for this? Councillor Illingworth, you're seconding.
I'm happy to second.
Thank you. Just give me a second. Can I ask members if they have any comments on the report? No comments? Okay. We'll move on to summing up. First of all will be Councillor James as the amendment. Can you sum up, please, if you want to?
Yeah, sure, Convener, and thanks for allowing me. Yes, I think our officers have looked at this. I totally respect the views of the local residents and their real concerns over the Vennel. That's not for us as a planning committee. That is a private matter, and I believe I think it was Mr. Brown mentioned their solution for dealing with that roof line from within the property without obstructing the Vennel. So I think everything else about it's a building that's already there. Yes, there's some changes to it, and yes, it's providing a family home. So I think it's an acceptable plan, and quite happy to propose its acceptance. Thank you.
Thank you, Councillor James. Bailey Williamson, do you wish to sum up? No, not at all. And now hand over to Mr. Fogg to confirm the terms of the motion and the amendment. Thank you.
Thank you, Convener. I will do that. Maybe just before I do so, I should pick up on one comment made by an objector, I believe it was Ms. Pulowska, who commented that as a single person, the scale of the property is beyond the needs of the applicant. I'd have to advise the committee that it's not a material consideration. The personal circumstances of the applicant aren't relevant to the merits of what's before you and shouldn't be factored in. That said, the motion is by Bailey Williamson, which is to refuse the application on the basis that the mansard roof design is not of a traditional Scottish approach and is thereby contrary to background policies 1A and 1B, and also residential policy 17 of local development plan, and that motion is seconded by Councillor Waters. The amendment is Councillor James, which is to approve the application in accordance with the recommendations in the report of handling, and that amendment is seconded by Councillor Illingworth. I'll pass over to my colleague now, Jess Gill, to take the roll call vote.
Thank you. Members, when I call your name, please let me know if you're voting for the motion to refuse or the amendment to approve. Bailey Ahern.
Amendment.
Councillor Allen.
Amendment.
Bailey Brock.
Amendment.
Councillor Harvey.
Amendment.
Councillor Illingworth.
Amendment.
Councillor James.
Amendment.
Councillor Leishman.
Amendment.
Councillor Massey.
Amendment.
Bailey McLaren.
Amendment.
Councillor Stewart.
Amendment.
Councillor Reid.
Motion.
Councillor Waters.
Motion.
Bailey Williamson.
Motion.
Thank you. I have 3 votes for the motion and 10 for the amendment, and therefore the amendment will carry.
Thank you. Therefore, planning permission is granted subject to conditions contained in the report of handling. Thank you. We now move swiftly on to item 513, which is the erection of a dwelling house and associated work land 50 metres west of Ruckleside Farm, Comrie, Creef. And to introduce the report is Mr. Williamson. Thank you.
Thank you very much, Convener. The next application for consideration today relates to the erection of a new dwelling house at Ruckleside Farm, which is located between Comrie and Cultybragan, with the water of Ruckel approximately 100 metres to the northwest. This application has been referred to committee in light of the receipt of 16 letters of objection and also 5 letters of support. Those submissions are summarised within section 29 of the report. In most part, the concerns relate to the housing in the countryside policy, flood risk, the need case for development and viability of the business. In support, submissions highlight the economic benefits of the proposal and the benefits of removing derelict buildings. As outlined within the report, while there is a slight conflict between the Local Development Plan and National Planning Framework 4, the latter takes precedence. While the agricultural needs specifically of the proposal may not be particularly strong, given the limited scale of the farm, the proposal is fundamentally being supported in light of the brownfield nature of this site, subject to the conditions listed within the report. I'll now take you through a short visual presentation. As already shown, the site is located to the southwest of Comrie, a short distance from the water of Ruckel. Access is taken from the B827 to the east. Next slide, please. Next, we see the positioning of the proposed dwelling. Members may see the faint red line showing the footprint of the buildings to be removed, with the house on the larger building footprint and a further building along the southeastern boundary. The neighbouring dwelling, Ruckleside, is shown to the right-hand side. Next slide, please. This next slide shows the 1 3/4 storey dwelling proposed in this instance. Walls would be rendered with Spanish slate to the roof. Windows shall be UPVC and the doors would be composite. Next slide, please. We now see the respective side elevations, with windows facing southeastwards being a satisfactory distance from neighbouring boundaries. Next slide, please. The floor plans outline the provision of the rooms, with the living space on ground floor and the 3 bedrooms at first floor level. I'll now run through a series of photos to outline the site context. These first photos show the existing dilapidated buildings on the site, together with the existing residential caravan, which has been placed there temporarily by the applicant. Next photo, please. This next photo is taken from towards the water of Rookham, shows the farmland in the foreground with the aforementioned derelict buildings in the middle, and then the neighbouring property Rookham side beyond to the rear. Next photo, please. This aerial photo seeks to show the existing arrangements more clearly, with the derelict buildings left of centre and the neighbouring dwelling Rookham side to the right, within relatively mature garden grounds. Next slide, please. Lastly, we show the alignment of the core path referred to within the report and representations. The path is shown in purple dash and follows the access road down from the south of Comrie across westwards towards the water of Rookham. The proposals in this instance would not impede the core path, although the council are aware of wider issues relating to access to the path in other parts of the applicant's site. However, they are not the subject of consideration to this application. Next slide, please. Thank you, members. That now concludes my presentation, and we now return to the site plan.
Thank you, Mr. Williamson. We have deputations on this item, so I'll hand over to the Vice Convener for the deputations process.
Thank you, Convener. Can I call on Ms. Waldron, objector to the application? Good afternoon. I'm sure you're aware that you've got 10 minutes for your deputation, and when you're ready, I'll just start the clock.
Is it working now? Right. Hopefully this will be a relatively brief submission because it relates to one very specific point within the application, which is about the application of NPF 4. But I do intend to say some other make some other comments on the report by Mr. Littlejohn, which is before you, and in particular the appraisal section of that report. I am one of the objectors. You will be aware that the application is before you because there are 16 objections from local people in Comrie. I'm one of those objectors and I'm here to represent those objections. Mr. Littlejohn's report gives you some background and history to the site, but I would like to add a little to that. The proposed site is agricultural land. It's situated between two of the three fields owned by the applicant since May last year, and described in the application as land at Cultibragan Farm. Cultibragan Farm was a large working farm which was sold in November 2022 to Otter Forest Limited. That company proceeded to sell the land in small parcels to disparate buyers, and Cultibragan is no longer as such a working farm. Title to the three fields on which the site is based was transferred by the company to the applicant on the 4th of May 2023 for no consideration, no price, and title has been recorded in the Registers of Scotland as transferred for love, favour and affection. Otter Forest Limited has one director, Mr. Laird. He's the sole shareholder, and he has numerous companies registered with Companies House. He would seem to be an entrepreneur, and that transfer of land at no cost would seem to raise the question of whether there is a back agreement. We're not naive. People do transfer land on the basis that the price will be determined by whether or not there is planning application, but it does planning permission, but it does raise the issue of whether there is a back agreement here and whose beneficial interest is being served. The first application to build a house on the site was made 4 months after the transfer in August last year and withdrawn in November and replaced by the current application. In December 2023, it was decided by the council that a prior notice application to build an agricultural shed on the site was covered by permitted development regulations and planning permission wasn't required. It's not disputed that the two agricultural sheds on the site are in a poor state of repair, but both are in use, one housing cows as we speak, and the other for storage of agricultural equipment. Other farm equipment is visibly stored on the site. Prior to the applicant taking title, the site was open ground between two fields. It has since been fenced off with barbed wire and notices warn walkers on the core path, which bounds the site, of CCTV cameras operating. Importantly, the history of the site's use and its present use are as an integral part of a working farm, albeit now a very small one. Turning now to the appraisal section of the report prepared by Mr. Littlejohn, which begins at paragraph 32 of his report. It's not disputed that the relevant policy in the local development plan is policy 19, housing in the countryside. And though the report does not say so at paragraph 35, it lists the qualifying categories specified in policy 19. Paragraph 36 correctly excludes the application qualifying under categories 1, 2, 4 and 5, and then goes on to deal with whether it qualifies under number 3, new houses in the countryside on defined categories of sites as set out in section 3 of the supplementary guidance. Paragraph 37 of the report lists the qualifying categories for new houses in the countryside under section 3 of the statutory supplementary guidance. Paragraph 38 concludes that category 3.3 economic activity is the relevant category for consideration of this application. And paragraphs 38 and 39 go on to analyse the evidence provided in support of this category by the applicant. Paragraph 40 concludes that the application fails to meet those requirements. A number of the objections lodged with you analyse critically the requirements of this section against the evidence provided in more detail than this appraisal. And the conclusion that it doesn't meet the requirements for economic activity in category 3.3 of the supplementary guidance is not disputed. Our view is that it doesn't meet that requirement, and it was right to reject the application on those grounds. And I would also add that for the avoidance of doubt, that Schedule 1 of the Welfare of Farmed Animals Scotland Regulations 2000, which has been relied on in the report submitted for the applicant, does not require residents on site to care for cattle. Turning now to paragraph 41 of the appraisal, it was on to consider category 5 of policy 19 for the building of a house in the countryside, which is the conversion or replacement of redundant non-domestic buildings, and explains why the requirements of this category are not met by the application. And it similarly then goes on to explain why the application does not meet the definition of brownfield land in the supplementary guidance. Again, that conclusion that the application doesn't meet the definition of brownfield land in the supplementary guidance isn't disputed. I would add that a material provision in policy 19 of the local development plan has not been referred to in the appraisal for no real understandable reason. At the conclusion of the 6 qualifying categories on page 35 of the local development plan, the policy states the application of this policy is limited within the green belt to proven economic need, conversions or replacement buildings. And that is reiterated at page 3 of the supplementary guidance, housing in the countryside. The application of policy 19 is limited within the green belt to proven economic need, conversions or replacement buildings. The purpose of telling you that is that this proposed site is within the green belt, with the settlement area for Cymru, and consideration of the application under category 6 rural brownfield land was specifically excluded. There was no need to go through the definitions to exclude it. You only needed to state that. But the definitions have been gone through, and we agree with the conclusion that it doesn't meet them anyway. Paragraphs 42 and 43 of the report contain the basis of the recommendation for approval. The recommendation rests solely on the different definition of brownfield land in FPF4, and we don't dispute that where there is a conflict, NPF4 will rule. It is represented that there is a wider definition in NPF4 than there is of brownfield land in the supplementary guidance, and the definition is indeed different. The definition of brownfield land is given in NPF4, and it is quoted at paragraph 42 of the appraisal. So brownfield, according to NPF4, is land which has previously been developed. The term may cover vacant or derelict land, land occupied by redundant or unused buildings, and developed land within the settlement boundary, where further intensification of use is considered acceptable. That last part isn't relevant. The appraisal in the report does not attempt to tell you why this site meets this definition of brownfield land in NPF 4, which is a little surprising given the earlier effort devoted to unnecessarily explaining to you why it didn't meet the definition in the local development plan and the supplementary guidance, when it was excluded anyway within the green belt. And it is important that it doesn't attempt to tell you why it qualifies under NPF 4, because that is a decision that you have to make. Why does it meet the definition of brownfield land in NPF 4? If we deal first of all with the first part of that definition, land which has previously been developed. Development is a legally defined term, and it's defined for all planning purposes in section 26(1) of the Town and Country Planning Act 1997, which says in this act, development means the carrying out of building, engineering, mining or other operations in, on, over or under land. We don't need to go further because building in the form of 2 agricultural sheds, has taken place on this land and would constitute development. But there is an exception to that, and the exception is contained in the following subsection 26(2)(e). It says, following operations or uses of land shall be taken for the purposes of this act to involve, shall not be taken for the purposes of this act to involve development of land. The use of any land for the purposes of agriculture or forestry, and the use for any of these purposes of any building occupied together with land so used. Whether land has been previously developed is a matter of law. These buildings were erected for agricultural purposes, the land is still used for agricultural purposes, and it does not therefore meet that part of the definition. The brownfield definition goes on to state in NPF 4 that the term may cover vacant or derelict land, land occupied by redundant or unused buildings. Right, the key word there for you is may. It is for you to decide whether what has been established is dereliction or redundancy. Thank you. Yes. Yes.
Thank you for your deputation. Ms Waldron, are you willing to take questions from members? Ms Waldron. You don't have to if you don't want to, but you have. But we'll give the chat a chance to populate and we'll see if there's any questions. Thank you. Councillor Harvey.
Thank you, Vice Convener, and thank you very much for your presentation. I just wanted to, I think we maybe need a bit of clarity just with your final conversation regarding brownfield land and the designation of it or the description of it. Looking at Google Maps, this area does look as if it has been developed partially in the past, which would mean transferring it to greenfield land is virtually impossible. Is the definition of brownfield maybe not just semantics in this case?
I don't think the definition of brownfield is semantics. The reason it's not semantics is that it's actually defined in NPF 4 and that you're obliged to follow NPF 4. So if it doesn't meet the definition that is there, if it isn't land that has previously been developed, and it can't be because that's excluded by the exception in section 26(1)(2)(e) of the Town and Country Planning Act, because these buildings were for agricultural use, that's an exception. So it can't be land that's been previously developed. You can go on and consider the extended definition NPF 4 if the land is vacant, derelict land, or land occupied, redundant or unused buildings. There's nothing in this appraisal report that tells you that. I notice it was mentioned when the photographs were being put up that there was a building that was derelict. That's not mentioned in the appraisal. That's not mentioned any place in the report. There's no claim of dereliction of a building. And in fact, I think it would be factually incorrect. These buildings, it's well known by the objectors and the local community, are well in use. This is worked as a farm every day of the week.
Just to follow up, Vice Convener. So sorry, I wasn't. I was just trying to kind of pull out what you. Yep. Sorry, I was just trying. So you, in your opinion, then, this land is not brownfield.
It's not brownfield land. I'm asking you to find it's not brownfield land, but you do have a discretion. I don't think you have a discretion in deciding that it's land that was previously developed, because I think, the exception in 26(1)(2)(e) excludes that possibility for you. It isn't land that was previously developed, but the definition does go on to say that the term may cover derelict land, land occupied by redundant or unused buildings. But you would have to make that finding, and that is contested. And there's no evidence submitted in your appraisal report that any of those things apply.
Councillor Allen.
Thank you, Vice Convener. Thank you, Ms Waldron, for your deputation today. I'm going to ask a question and then follow up with a supplementary. Do you live close by to this facility?
I'm in the village.
And can you tell me, are you happy with the current derelict outlook?
Well, I would have to contest that it's a derelict outlook. As you'll see from many of these objections, what has arisen, and many of the objections have been fueled by the fact that there are core paths which pass this area and which are used very frequently by walkers and local people walking those paths for generations. Of course, they don't object to it. It doesn't look derelict. It's just been part of a farm, an area between two fields on which machinery was kept. It wasn't fenced off with barbed wire or anything before, or notices about CCTV cameras. It's the kind of typical areas you get in farms, and it always has been. It was as long as it was owned and worked as Cultibragan Farm.
Councillor James.
Thanks, Deputy Convener, and thanks, Ms Waldron, for your deputation. I'll return to NPF4, which you quoted quite a lot, and you're asking us to make a decision on a brownfield site. NPF4 is quite overriding for us, and I'm looking at policy A2, which states it reuses a brownfield land where a return to a natural state has not or will not happen without intervention. Would you agree that it would need considerable intervention to return this to greenfield, please? Thank you.
Can I just say that that's putting the cart before the horse? The provision you've referred to refers first of all to it being brownfield land. It says brownfield land which cannot. You've got to be satisfied in the first instance that it's brownfield land. You don't justify what you think maybe happened to it, or should happen to it, or not happen to it, or what could happen to it, and then say that's brownfield land. It's the definition in NP4F4 which decides whether it's brownfield land. And I think there's a little bit of too much of a perhaps inclination, understandable, to simply look at sites and say, oh, it's got a bit of rubbish on it, it's looking a bit untidy, there's a building in need of repair, it must be brownfield land. This is part of a working farm. There's been a permitted development application for a shed. The response to a dilapidated shed in agricultural terms is build a new one, and that's already been granted.
Ms Waldron, there's no further questions, so you're free to go. Thank you. Can I now call on Mr Wallace, applicant? Good afternoon, Mr Wallace. I'm sure you're aware that you've got 10 minutes for your deputation. I'll give you a prompt after 9 minutes. So whenever you're ready, just press the mic and on you go.
Good afternoon, ladies and gentlemen. I wonder if whether I maybe should clarify one or 2 points that Ms. Waldron made first of all. How's that? With regard to her first point, the ownership of the farm, if you checked out the report of handling, you would see that we sent a letter from our solicitor to the planning officers, pointing out that we did in fact pay a large sum of money for the land, and we didn't get it for nothing. So I just wanted to clear that up just now. The other planning matters, I would pass that to the planners who are far more qualified than I am. Sorry. Right, sorry, I'm maybe just a wee bit quiet spoken. So I'll start off here then. Good afternoon, and thanks for giving me the opportunity to speak today. We bought the land and buildings that were formerly part of Kiltybraggan Farm at Ruchleside on the 9th of May 2023, having previously farmed in Perthshire for approximately 40 years on a 200-acre plus arable and livestock farm. When we were first offered the land, approximately 70 acres, I was told that there was already an offer in on the buildings and 10 acres from a neighbour who was a property developer. This turned out to be Mr. and Mrs. Templeton, our neighbours next door. The agent came back to us some months later to offer us the buildings as well as the 10 acres along with the rest of the land as a whole, because the offer on the buildings and 10 acres had fallen through as the buyers failed to come up with the funds. Since arriving in Comrie, I widened core paths, rights of ways around my farm and put gravel down in wet, wet areas. I have provided a new path leading to Aris Field for the walkers, and Callum Batchel of Green Space will attest to this. In fact, I had a meeting with Callum and his boss last week, and he confirmed that I'd never at any time blocked any core paths or rights of way, nor had I restricted access to the river or these other areas. I've been thanked by horse riders, cyclists and walkers for widening the path to enable them to use it more easily. With regard to the plan application, I feel is necessary in order to ensure the welfare of my animals. We now have 20 cows and at present 7 calves. All the objectors' false allegations re animal neglect have been proved 100% untrue, as testified by Perth and Kinross Council's own Animal Health Inspector, SSPCA, Department of Agriculture, and my own vets. I'm certainly not a hobby farmer, and I'm certainly not on record as saying this. I work 7 days a week, and I employ a local young lad from Comrie who works on a part-time basis. I'm present trying to arrange an apprenticeship for him in order that he can become a full-time employee. I recently put in a prior notification for a new general purpose shed, as the buildings that are there do not lend themselves to modern farming practices. In particular, one of them's a particularly low building. It's a slatted floor with slurry tanks below. We have cows and calves. No farmer would keep cows and calves on a slatted shed. It's just nuts. So the site is presently being cleared to the construction of this new shed. I've already invested over £500,000 of my own savings into this farm, and as mentioned earlier, I have over 40 years experience in farming. It's my intention to plant approximately 4 kilometres of hawthorn hedging along with shelter belt trees and wildlife corridors linking all the various habitats. And I also have the benefit of consulting with local farmers who contract farmed my land in the past and whose knowledge has been invaluable. The neighbours' amenity would greatly be enhanced by the construction of a new house and garden landscaping rather than the old dilapidated asbestos roofed buildings. The proposed house is slightly below the existing house and therefore there is no overshadowing. Sympathetic landscaping will be adopted, which is an approach that incorporates companion planting, wildlife-friendly gardening, and maintaining plants and planting new trees suitable to the local area. As a new shed is now much further away from the existing house at Ruckel's side, any noise or agricultural smells will be greatly reduced. Although on a visit from the Environmental Health recently, they confirmed that they had no concerns at all. This is a high quality design in keeping with other houses in the area, and locally sourced materials and labour will be used where possible. There are no traffic issues as the farm machinery is on site most of the time, and there is more than ample room for parking at the farmyard. I have full access rights over the access road for all purposes, including agriculture. The person who now owns the access road and is my neighbour and owns the remainder of Culty-Bragan Farm, which I can assure you has been farmed as well. He actually supported my planning application. So should this excuse me, should this application be granted, we will ensure that during the building that the access road will be kept clear of vehicles whenever possible, and the core path will not be blocked so that walkers can still use it freely and safely. I have qualifications in health and safety on construction sites and lots of experience in this area. A new house in this situation instead of the old buildings will enhance the character of for both the locals and the visitors alike. But with regards to the drainage plan, a detailed drainage plan will be submitted at the building warrant stage should this planning application be granted. And while I understand that a few local people find change difficult to adjust to, the minor changes I have made and intend to make will greatly enhance the biodiversity in the area and are necessary to ensure farm profitability. As mentioned earlier, I have constructed new paths and widened others, and I have also put up fences, as I'm now undersowing my barley with grass in order that my cows can graze the grass fields after the harvest is over. This will ensure that the farm is self-sufficient and produces its own fodder for the cattle along with the barley crop. I was unaware of the long-running battle between objectors and the previous farmer when we purchased this land and buildings. People trampling crops, dropping litter, not picking up dog excrement from the path, cutting fences and letting out of control dogs in amongst the livestock. Unfortunately, these behaviours still exist today, and after the previous farmer died, some people treated the farm like a public park. However, it has now been sold to us, and it is how we make our living and is not a public park. And I would ask the objectors to respect us. Encourage the use of the core paths and the rights of way, now made more accessible by myself. And I'd also like to say the vast majority of Comley people they're lovely people, and it's just a small cohort who do not behave responsibly. I've been slowly building up this farm business, and this month I am planting a high-value vegetable crops and malting barley. That's if the weather ever dries up. I've also increased my cattle numbers, as I said before, to 20 cows, and at present we have 7 calves. I will continue to grow the business as far as I can, and I thank the committee for listening to my deputation.
Thank you, Mr. Wallace. Are you willing to accept questions from members? We've got questions in already, so we'll start with Bailey McLaren.
Thank you, Mr. Wallace. My question is sort of a wee bit more around your agricultural operation. Just to bring out some facts of detail, your herd, it's a few points to the question. Do you plan to increase that herd size? Is that herd, are you registered with QMS? And I'm making a presumption that your shed storage could be deemed as red tractor status towards the end of its natural life, and therefore for herd health, you also require a new shed. Thank you.
Yes, you're quite right. As I said earlier, the main shed that's there is a slatted shed. It's concrete slats on the floor with slurry tanks beneath. Sorry, I'm just, some people might not know. I've never been a lover of these sheds, and they're really poor for animal health. So, I mean, I'd like to. You wouldn't want to leave an animal sleeping on a concrete floor. You know, it's just not. It's not. I wouldn't do it anyway. So, for that reason, we're putting up a new shed, and it'll be part of it. So half of the shed will be for the cows. And in answer to your question, I don't intend to take it much more than 20 cows and calves. The cattle we have are Angus and Angus crosses, so they're not big cattle. So that's probably be about the limit for the land without taking on more. When you're given the price of cattle just now, I might be tempted. Sorry. So does that answer your question?
Well, it was just the QMS bit. Are you registered? But I'm presuming now you've mentioned that with your 20 cows and everything, you're maybe not as registered with Quality Meat Scotland QMS. But that's irrelevant. It's actually irrelevant to our planning application. It was just trying to understand where you were going with your cattle in the business. But I clearly can pick up you're a committed farmer. Thank you.
Councillor Harvey.
It was already answered. Thanks.
Mr. Walls, there's no further questions. You're free to go. Convener, there's no further deputations even. I'll hand back to yourself.
Thank you, Vice Convener. Can I ask members if they have any questions for officers? Oh, I do apologise, Councillor Donaldson. I'm not looking at my script. Sorry, can I call him Councillor Donaldson? Thank you.
Thank you. And can I just say, Convener, Vice Convener, members of the Planning and Placemaking Committee. First of all, thank you, Convener, for agreeing to let me speak for 5 minutes. And I'm here, I just say to Bailey Ahern, a very similar capacity to Councillor Lane as a local ward councillor. And indeed, in just a few minutes, if I get the chance to ask 1 or 2 questions, I may be sitting in a slightly different environment in these chambers to what I usually do, but I'm sure Councillor Allen won't object. Let me cut to the chase, because limited time. I think Sheena Waldron made the key point. The key determinant here are the words brownfield land or rural brownfield land. How is that defined? How indeed is that interpreted? Before I come back to that, I think there are 2 points I would want to make. First of all, under point 30, there has been controversy in Comrie, and not just over recent times, but with indeed, Mr. Walls referred to the previous owner. But it does state the behaviour of individuals or speculation as to their future behaviour is not a planning matter and should be pursued under civil law where necessary. And I agree entirely. But on the paths issue, it just cannot be that the adjoining land, the adjacent land, is entirely separate and divorced from this planning application. Indeed, the whole issue of core paths, rights of way, and access to paths that are commonly used and should be used under the Reform Scotland Act goes back to certainly mid-July of last year. And Mr. Walsh referred to, and I don't know the full outcome of his recent meeting with Greenspace, but the one thing I would say here It's not just about the barbed wire fence between Culty-Bragan and the right of way at 25-2. It's also the path adjacent to the core path down by the side of the River Rúchal. It's absolutely crucial because it's so important, Comrie, given its path network, that the core paths and rights of way are indeed protected both now and going forward. I'll just make the point about that path down by the Rúchal. The path along the edge of the field is not designated as a core path or right of way, but a right of responsible access does apply along it. Access rights do not apply within the field itself whilst it is in crop, and indeed outdoor access code must be upheld. But the path is well used for many years as a safer alternative to the core path, which is eroded in several places due to flooding from the Rúchal water. And it really is imperative that whatever, if this application were to be approved, and I argue it should not be, that those rights of access for local residents, which they've cherished over generations, must be defended to the very hilt, and they mustn't be circumscribed. And the very fact that this has been ongoing since mid-July of last year, I think speaks volumes. But to come back to the point, on the question of brownfield land, it seems to me, from what I can in fact take from the paper, and I think Sheena Waldron went into it in great depth and far more effectively than I can. But surely there's certainly under Local Development Plan 2, under Policy 19, housing in the countryside, and also supplementary guidance policy, then this application would not succeed. But I think there is a real question of, with National Framing NPF 4, with Policy 9 on brownfield site, and I refer you once again to paragraph 42 in the main paper, and I think, and also paras 43. I think there's real questions here as to what is brownfield land for what it is actually an ongoing farming enterprise. There may be questions about its viability. It's, I think, what is it, 26.1 hectares, and the SAC report, I just don't think stands up. But I will conclude, I do have real concerns. Thank you.
Thank you, Councillor. Do you have any questions for? Yeah, we do. Councillor Harvey.
Thank you, convener, and thank you, Councillor Donaldson, for your presentation. Could you just kind of tease out what's your concern about the core path issue? Do you think the core paths could be blocked in future, or could be a problem with them in this area? Thanks.
Okay, there was quite a detailed note done up by Greenspace on Rúchal side access issues. It went to Community Council and many others, and that was done in September. One of the issues there was the barbed wire fence between Culty-Bragan and access to the right of way 25-2. And that's still ongoing. There is a gate there, but it's impossible to open. But it's also the path I referred to down by the side of the Rúchal that is a safer alternative to the core path that is eroded. And it's a path that has been used over many, many years by people. However, that path is currently blocked off. It's fenced in. So there is a question there, and that is a matter, I think, that has to be resolved. But I think it's so important because Comrie does have a really good path network for local residents. It's something they cherish and they treasure. And public access is an important aspect under NPF 4, although I recognise this particular planning application relates, if you take it very narrowly, to a house and associated buildings. Okay.
Thank you.
Councillor Allen.
Thank you, convener, and good afternoon, Councillor Donaldson. Thank you for your deputation. I'm just coming back to the issue, I think my colleague Ken has just asked you something similar, but I take it you weren't convinced by Mr. Wallace that the core paths will be protected. Within our recommendations, recommendation 9, it suggests that they will be robustly protected. So can you help me understand what the problem is within all that? Thank you.
Yeah, I refer to, and I'll even let you have a, that is in September of last year, 2023, and it sets out the various access issues. And unless there was something that did come out of the meeting with Green Space last week, I think it was, then this has been ongoing now for 9 to 10 months. So hence I question, you know, the certainty of people having access to these paths. And the one down by the Ruchel does matter. It is adjacent to the field. And I certainly totally oppose anyone that runs onto the field, especially when there are crops there. There is the outdoor access code. But in general, it has been used by local residents. It's valued, it's cherished, and I think it does matter. So why is it being fenced off? Yeah.
Councillor James.
Yeah, thanks, convener, and Stuart, thanks for coming along and making a deputation. My question, I guess, has kind of been answered, but I was looking more for clarity. There is a core path there, as you say, but the path that you're questioning, and you're saying the landowner has put a barbed wire fence up, that's been self-made by people who choose to go down that route, and the farmer is actually protecting his livestock. Am I right in thinking that?
I would say that this is a path that's been used over many years. I think we could prove that. And I think it's a path that, and I just give you the wording, is the path is well used for many years as a safer alternative to the core path, which is eroded in several places due to flooding from the Ruchel water. As I say, I don't think you can entirely separate the adjoining adjacent land from the actual building, but that path it does matter, and I think certainly if it was under the Land Reform Scotland Act 2003, then public would have the right of access. It gets quite complicated because if you've got core paths and you've got rights of way, but there's no doubt in my mind under the that act, that legislation 2003, people do have a right of access to use that path responsibly.
Convener, can I come back on that, please?
Yes.
Stuart, sorry to labour it. I think what I'm looking for is that this is, a kind of self-made path, if you like, or right of way, as you say. But does this go through the plot of land that's subject to a planning application today, or around it, or is it nothing to do with this planning?
No, but it is adjoining land and it's adjacent land. I don't think you can separate the two. And I think certainly for the purpose of building the house, the path that comes off the road to going up towards Auchengareth, what's it, the B927, then that certainly we've got to be absolutely certain that access is maintained and maintained at all times. So that's crucial. But I do make the point, I made the point on the core paths and the rights of way, because it is something that should be, we've not actually gone public on this before, and simply because we wanted to get a negotiated settlement for Mr. and Mrs. Wallace to reach agreement with Green Space, but that has not, unless there has been a change the last few days, that as far as I can see has not happened. And it is something like 9-10 months. that I may be corrected, if there have been developments the last 2-3 days. Okay.
Mr. Wallace, you've raised your hand. I assume that you want to respond to that part that Councillor Donaldson said. Can you speak, Councillor? Can you move, please? Just a second. Could you please go to the lectern? Yep. Oh.
I think it probably would be better if I sort of explain things. And maybe perhaps if I've been trying since July last year to speak to Mr. Donaldson. So I had a meeting, as I said, with Callum Batchel and his boss a couple of weeks ago about this barbed wire fence. It's part of our boundary fence between ourselves and CDT and the farmer who owns Kiltybraggan Farm. Now, we'd agreed to put a stile in here, but I don't own the land on the other side, so it has to be at a negotiation with the owner on the other side. But subsequent to that, we discovered that CDT are in breach of the burdens on their title deeds, because they're supposed to erect a secure fence around about what the building is on the 3 acres that they own, and that building's a munitions hut that stores live munitions. So as soon as they put the hut up, the fence up, you wouldn't get through it anyway, because you're not allowed to go past a building as part of the right to responsible access. So there's a lot of negotiation to be done yet, but it's not just as simple as I'm saying no to this. You know, there's another 2 people have to be taken into consideration too. So I was just
thank
really
you.
To clarify, if I hope that helps. Maybe I've made it worse.
Okay, thank you. Switch your.
Yep.
Councillor Donaldson, there was still another question for you. Bailey Brock.
Thank you, convener. Councillor Donaldson, we're speaking very much today on the core path here, which is quite rightly so, because it is a particular one. And you're saying it's been used for many, many years. Are you aware at any time that there has ever been any obstructions? And I'm quite concerned over the barbed wire area, to be honest. Because this has been used, I believe, as a working farm, and the buildings have been used for that for a considerable number of years. So I'm just now asking, has there ever been at any time in the previous owner's end that there has been any blockages or anything made on the core path, or that's brought this to come to where it is today to be blocked like this?
Can I, before you answer, Councillor Donaldson, I've been very lenient with everybody. You're asking questions about core paths and that. We're actually here to look at an application for a house. I know these core paths are of great significance for many members within the committee, but I think we should really get back to what we're actually here to determine, which is an application for a house on that land.
Convener, can I just come back in there? What I'm actually looking for is, because the access will be going past the proposed house, is really what I'm working on, to see if there's been anything at any time that's blocked that area. That's really basically what I'm asking.
I'll let you answer that, Councillor Donaldson, in one word. Yes or no?
Not as far as I'm aware. There.
Councillor Donaldson, if you'd like to take a seat. Thank you. Okay. Can I ask members if they have any questions for officers? Bailey Ahern, you had a question.
Thank you. And apologies for putting it in before Councillor Donaldson managed to get up there. I just want clarity over this brownfield site, whether it's brownfield. Ms Waldron was in the process of saying that, I think it was section 21(1)(e), that there were exceptions, and she was listing the exceptions as to why it shouldn't be, but never actually got to complete that. So can we just get clarity whether it is fully classed as a brownfield site and that it doesn't come under any exceptions? Thank you.
Yes, thank you, Bailey. I can certainly cover that and the interpretation of Mrs Waldron of the Town Country Planning Scotland Act 1997, section 26(2)(e), and how that relates to MPF 4, which is Annex F. That's the glossary of definitions, which sets out what brownfield is to be taken as in relation to MPF 4. So it's my advice that, and again, this is a very complicated legal issue that I appreciate may be difficult for lay people to understand clearly. But Mrs Waldron has a different interpretation of section 26 than what planning officers have. And I would just say that section 26 is the most reviewed and quoted by planners of any section within the Act. It's probably the first thing that we are referred to on our first day at planning school. Now, particularly section 26(2)(e) excludes the use of a building for agricultural activity from being development. But that's importantly not to say that the building in itself is not development. So if the building is development, just not its use, then it can be considered as development and constitute brownfield land in terms of the definition within MPF 4. So, I mean, I can quote section 26(2)(e) to you, and it says the use of any land for the purposes, so it's again, the use of any land for the purposes of agriculture or forestry, including afforestation, and the use for any of those purposes of any building occupied together with so land used. So that's the exclusion. But it's the use of the building, it's not the development of the building. So the building in itself is development. It's just the use of the building that is not development. So my advice is that Ms Waldron is misinterpreting the meaning of sections 26(2)(e) and how that relates to what is or is not development. My advice is that the buildings and the development of physical matters at that location is development and could be considered as brownfield under the definition within Annex F of MPF 4.
Thank you. Councillor Waters.
Just on the same theme, and I am struggling with this one, but understanding the set out of the site. So the applicant wants to build a house where one of the existing buildings, which the applicant says he just doesn't like, you know, for whatever reason in his deputation, and then there's a silage pit right next to it, and that's the area the house is going on. Next to that, from aerial photography, there seems to be some scrubland, or what most of us would probably identify maybe as if it's brownfield or not, possibly. But there's already a approved development for a new shed going there, rather than on the existing shed. So basically, he's then building a shed in a separate application, and then going to tear down the shed that's already there, so not replacing that, and then wanting to build his house where the shed and the silage pit is. That the idea? Because I did see one drawn online, and it's very difficult. The one you've got up there, when I looked, you don't see, but there's grey markings on it, but you can't see it on the screen or anything. That kind of gives a rough. But even looking at the drawing on the planning portal, it's difficult to make out. It just shows what's getting done without any real context that's visible around it. But I think there was one drawing on the on the within the application on the portal that gives a better view. That doesn't show the house, but at least it shows the extent of the plot, and that is. And I don't understand. I could see half an argument why the other side might be brownfield, but I don't understand why an existing building that's currently standing and the silage pit, which on aerial photography currently looks like it's in use, i.e. looks like it's half filled and get used. I thought brownfield wasn't to be in use. So you said, I would just say, because he's basically all we're doing is replacing, and he's moving a building elsewhere and then replacing it with a house where that building was.
Yeah, maybe in very short response to your long question, yes, it previously developed land, so land which has been developed is brownfield. It's probably the short answer to it. So yes, it may well be in use, it may no longer be in use.
But then every bit of land could then be brownfield if it's still, you know, if you're saying it's not because it's in use or not in use is not relevant here, then anything becomes brown land, because anything where you've got buildings or anything is just existing. I always thought brown land had to be something that is not in use anymore.
Not necessarily, no.
So everything's brownfield.
Everything which has previously been developed and has not regenerated itself. Again, in lay terms, I'm not quoting you detailed guidance on it, but yes, in lay terms, anything which has been previously developed and has not regenerated itself in order to deal with perhaps an environmental issue.
And what's, I wonder, what do you mean by regeneration? I mean, they've got farm buildings there. We've got a silage pit there where the house are, which, you know, as far as we're led to believe by deputations, is still in some kind of use. Whether I think Bailey McLaren used red tractor as a term. I don't know. Not being from the farming community, but that means it's just fit for storing tractors or machinery. Is it more than that? The quality of the land, right? Well, the building's still in use to some extent, and the silage pit looks like it's still in use. Is that correct or not correct, or is it not in use anymore?
If I could come in there, Councillor Waters, and with hindsight, it would probably have been useful for me to have a separate slide to show the agricultural building, which was approved through the prior notification scheme. But obviously what we see on the screen in front of us at present is obviously the site of the house, which is on the site of the existing buildings, which are in an exceptionally poor condition with a low pitch to the roofs. The area of grey next to that is a silage kind of hard standing area. That's not a silage pit per se, but the building which is being proposed by the applicant, which has obviously been approved via prior notification, is beyond the road to the northwest. So it's just northwest of everything that you see there is where that proposed new building would go. But the site of the house itself is within the confines and footprint of the building, which is in a poor state. And yes, the applicant has admitted that it is still used to a certain capacity, but it doesn't fit the needs of modern farming.
Thank you.
But he's still sort of.
Councillor Waters.
Apologies,
So,
but
no,
he's still replaced.
Councillor Waters, your question has been more than answered.
Not to my satisfaction, but
well, Councillor Waters, in NPF 4, brownfield sites are land that has previously been developed. The term may cover vacant or derelict land. That's only part of it. In policy 17, reuse policy 17A2, reuse brownfield and land where return to natural state has not and will not happen without intervention. When the new building shed goes up, that shed will then become redundant. That shed is redundant then. That shed is not, you cannot repair the shed. It's not suitable for repair according to what the report is saying. So that is, well, I don't want to say this, but we don't want to put words into people's mouths of that. That is brownfield. That then becomes brownfield land, from my interpretation of it.
So it's not brownfield land yet until the new one's finished and it's moved into it. And just to sit and say that
we're going round in circles.
The applicant Strawn that says silage pit, not me. It's applicant Strawn.
Yeah, I maybe just reiterate. The view of officers to you is that this site is a brownfield site as per the definitions both in the Town and Country Planning Scotland Act and the related definition in NPF 4. It's land that's previously been developed. Carrying on from what the convener said there, beyond covering vacant and derelict land, it could be land occupied by redundant or underused buildings and developed land within the settlement boundary where further intensification of use is considered acceptable. I think the explanation in terms of the farming activity here is, yes, there are buildings that are in use, but they are less than ideal and have served their purpose, and the applicant has gone through the due process to get permission for a new modern facility that meets the requirements of modern farming activity, husbandry, security, welfare of animals, etc. But yeah, I would just say that we as officers are giving the advice that this is a brownfield site and it meets with the terms of NPF 4 and the definitions within the Town and Country Planning Act of 1997.
Thank you. Councillor Allen. No, sorry, Councillor Donaldson.
It was me first.
Well, was it you first? Oh, sorry, right.
Thank you, convener. At the risk of incurring the wrath of the convener, I'm just hopefully going to put everybody under concerns to bed. Recommendation 9, it suggests that any damage done to the core paths, which may include blocking or by any other means, will be made good before occupancy. I think that's enough to ensure that it'll all be done correctly. Thank you.
Thank you. Councillor Donaldson.
Thank you, convener. I have 2 questions, but the second is a supplementary to the first. I just want to exclude one thing and get clarity in one thing, and that is, had this planning application come in prior to national NPF 4 under purely LDP 2, that's policy 19, housing in the countryside, it would almost certainly, just to clarify, would have been rejected. Is that or not the case?
No. Thank you, Councillor Donaldson. Obviously, the position that we're in now is that NPF 4 is very much in force. So it is the primary consideration in this instance. If it had been 2 years ago, it may well have been a different scenario, but we are dealing with NPF 4 here and now.
Right, and the supplementary is, since it's almost certainly in contravention of LDP 2, and that gives a subsidiary reason for rejection, I hear what's being said about NPF 4 taking precedence in terms of the overall development plan. But can I just say to perhaps Christian Smith, it is about interpretation, and would I be right in saying that a reasonable person looking at all the evidence could take a different view on this and say that, sorry to go back to the point, that in fact this is not brownfield land?
I think all I would say in relation to that is I'm giving all due respect to the Deputy, Mrs Waldron, but my strong advice is that this is brownfield land and development in terms of the Act and NPF 4, and that is my professional advice to you.
Thank you. Councillor James, you have a point of order.
Yes, I do, convener. Actually, I'm a little perplexed today, to say the least. As a member of the planning committee, planning and development, I've had to attend training and I had to go through a number of hoops to be able to sit on this committee, and with that, you're expected to have a level of knowledge. Today, we've got people who haven't, who are not on the planning committee, able to influence decisions. I'm not sure that that's right, convener. Perhaps our legal could advise.
You would have to take that up. That's it's within standing orders that they're allowed to do this process. that I'm allowed to give them permission to speak, that I'm allowed to give them permission to ask questions. It's in standing orders. If you have a gripe with standing orders, I suggest that you take it up with the head of legal and governance.
Is that even in a quasi-judicial committee like this, convener?
Yes, I took legal advice from the head of legal and governance, and that is what I have been told. So I'm going with that advice. If you feel something contrary, then I would suggest that you do ask head of legal and governance.
No, okay, I get that, convener. I'm just absolutely amazed. Thank you.
Thank you. Now, can I ask any more questions? No more questions. Can I ask for a motion? Councillor James, you've put in a motion.
Yes, I did, convener, because you know, we've had the discussions here around a core path which is out with this planning application. We've asked or been questioned about a brownfield site, which we now know this is a brownfield site, and it's a great application, if I'm honest. There's nothing that I can see which would prevent me from proposing its approval, so that's the way I intend to go, convener, which is to approve this application. Thank you.
Thank you. Councillor Reid, you seconded.
Yes, happy to second.
Thank you. Can I ask for an amendment? Or if there is an amendment, I'm not actually asking for one, but amendment. Just give me a second here. Can I ask if members have any comments on the report? Comments? The application is granted, subject to conditions contained in the report of handling. Thank you. We now move on to item 6, which is a proposal of application notice. And the first one is for mixed-use development comprising residential, self-built plots, commercial use workshops, associated infrastructure, including access, drainage and landscaping at land 165 metres southwest of Hog End Farm, Dunkeld. Do we have any comments? The first comment is Councillor Illingworth.
Yeah, can I ask the planners to consider the long-term maintenance of any suds ponds, the very long-term maintenance in terms of like decades and centuries of suds ponds, please?
Thank you. Bailey McLaren.
Yeah, thank you. I would just like to ask officers to give particular consideration to the scale, design and layout and the relationship to the nearby lands. Transport implications would probably have quite a strong importance, and the tourism and economy benefits. Thank you.
Thank you. Any more comments? None. So we'll move on to 6.2, which is the formation of a 400 kV substation comprising erection of ancillary buildings, hard standing, plant and machinery, access, laydown work, compound areas and associated work at Shindur, Ferrell Hill, Wood, Braco. Can I ask for comments, please? No comments? Okay then, thank you very much. That ends today's meeting. Thank you to everyone that has attended and all the deputies and the members of the public and especially the members. Thank you very much.